Guidelines. Get you listed tomorrow.
My lord, item 18.
Tomorrow or day after tomorrow.
My lord, item 18 supplemental listing take withdraw.
Item 18 permitted to withdraw.
I may pardon to mention your
My
lordship.
lord, item 30, my lord.
Just. Yes.
I may pardon to mention your lordship. RSA number 261 of 2023, your lordship. The applicant is a illiterate woman and old age, your lordship. Now the respondent created some false document and take to that valuable land, your lordship. May I play next week any date, your lordship?
Pardon
Yes.
to mention.
Deep progress.
Yes. Yes, please.
Item 30, my lord, supplemental list today.
Yes.
Kindly take up 1 week after. Yes, sir. 1 week after. Item 33-0.
Let it reach. There is some letter. Some letter has been received. We will see. Let it reach.
My lord, I am not available in Kotak. I have come to my village for a marriage ceremony. That's why I am praying.
It's all right. I'll adjourn it, but I'll see what has been there.
My lord, I am not available in Kotak, my lord.
All right. Let's
Item
matter
10.
1 week after.
My lord, item
Obliging, my lord.
Item?
Item 10, my lord.
Yes.
2 weeks time for filing rejoinder. I have already received the counter, my lord.
When did you receive the counter?
My lord, last
2017 matter.
2017, my lord. Only 1 week times for filing the
Will this matter
rejoinder.
tomorrow? Rejoinder if any be filed in the meantime.
Item 28, your lordship. Transfer petition. I am for the petitioner. My lord has referred the matter to the mediation center.
Yes.
Mediation center proceeding is pending for 22nd. This matter they are.
All right.
22nd this month.
It is submitted that item 28. The next date of mediation proceeding is fixed to
22nd July.
22nd of this month. List this matter on 30th July.
My lord, on item number 27, on behalf of Anurag Samantrai, let it come next week.
Next week is paid for.
My
Next
lord,
week, para?
Yes, my lord.
Item number is 12.
Item number?
12.
Yes.
On behalf of my learned senior, pray for adjournment.
Why?
My lord, the file was misplaced, my lord.
All right. List this matter 1 week after.
Sorry to interrupt, my lord. Item 10, 1 week.
Item 10 para kora na? Day after tomorrow.
Day after, my lord, actually petition from belongs to Kolahandi, my lord. Rejoinder file kari.
Tomorrow to karo, next week koi. No, next week. Next week.
With your lordship's kind permission, that Shiksha Act matter, which has been argued by my senior, Mr. Rautare. Your lordship have already concluded the hearing. And in one of that matter, I came to know that the name and surname of the petitioner are wrongly typed.
Has it been, is it reserved for judgment?
Yes, Lord.
Judgment is reserved for.
The written
Give
note.
a memo.
Man.
Give a memo.
I have filed an IU.
No, you give a memo, I'll have to list it for to be mentioned.
Look,
You file an IA. You have filed an IA.
mine.
Memo done yes.
Understood.
Get it listed tomorrow. Huh?
Pardon to mention, ma'am.
Day after tomorrow, yes.
This is RSA matter 2018 matter, ma'am, involving injunction suit of the residential house.
What is the urgency? Tell me.
Because the status quo order is there, the residential houses, they are not able to repair and do that.
No urgency. Yes. Anything else?
Item 37, weekly list.
Let it reach. Yes, item 1. Look.
Supplementary list, item number 1, fresh admission.
Matter was yesterday before your lordship.
Yes.
Lordship has been free to direct it to list it before assigned bench.
अरे हमको क्या असला? कौन क्या असला ऑफिस नो? पहले कौन वो listed before the assigned bench ना? हाँ? Same bench. कहीं हरान? Previous order be carried out by office by listing it before the assigned bench. Yes.
Item number 2.
Item 2.
Matter is regarding to disengagement of GRS.
Yes.
My lord, the termination is issued by the authority
on the ground of misappropriation of MNRGS. MNRGS scheme, but there is inquiry conducted, but there is no proper inquiry conducted, and the GRS there is no important role in this regarding because of the monetary transaction mainly occurred by the block level and the district level. But GRS, their duty is to work in the field, just like to collect data.
So what is wrong in that inquiry?
The wrong inquiry, first of all, in Bikram Maji case, in that panchayat, there is no inquiry conducted, but the authority has terminated that GRS.
Yes.
Terminated that GRS, and it was not, but there is no inquiry conducted in that in concerned panchayat, and that only 2 inquiries conducted, but the inquiry conducted in
Which matter are you referring to?
I am referring to disengagement of GRS.
Who matter? The WPC number kete kon?
WPC number.
Sanjay Kumar Dorai.
He says that no inquiry, but this is a order has been passed on 31/5/2024, Annexure 1. It seems there was some kind of inquiry. He's not holding a civil post, isn't it?
Apart from that, in an identical matter, I was directed to obtain the instruction that whether such type of order is appealable or not.
No.
On the last occasion.
It's applicable before the Director Special Projects. Director Special Project.
And he is the opposite fact number 1 in this case.
Director Special Projects. No, let him file an appeal.
Yes.
File an appeal.
But there is a 2-day delay has been.
No, that will be controlled.
30 days time has been provided on the comprehensive guidelines to challenge it in the.
So when did you file the writ application within time?
Yes, ma'am.
केबे डिसएंगेजमेंट ले 31/5 आप रिट पिटिशन के फाइल करले 10/7 अब यस माय लॉर्ड माने
एक साथ से
आज्ञा
एक साथ
रे कोन होई छै
एक साथ माय लॉर्ड एक साथ आई हैव फाइल्ड संजीव द्वारा डब्ल्यूपीसी नंबर
नहीं आज्ञा आपण जो रिट पिटिशन को धरि छै सेटा को आज्ञा कोंतु आपण यू आर टोटली कंफ्यूज्ड एंड यू आर कंफ्यूजिंग द कोर्ट गो स्टेप बाय स्टेप जो मैटर ऑफ आइटम 1 अछि आपनकर सेटा को धरन यू विल गो स्टेप बाय स्टेप
माय लॉर्ड 31/5 रे
Yes, the order was passed on 31/5.
Yes,
so you ought to have filed the case within 30th of June.
Yes,
you filed this writ application on 10th of July. Had you filed it within this time, I would have automatically condoned the delay. Now you will have to file a petition for condonation. All right. Then
I have filed on एक साथ माने एक साथ 2020
कौन फाइल पिटिशन
रिट पिटिशन
ये हमर लिखा है प्रेजेंटेड ऑन 10/7/2024 सुपरिटेंडेंट कंप्यूटर फाइलिंग स्टेशन फाइलिंग सेक्शन ये भूल करथिबे बोधे एक साथ को 10/7 कर दीते 10 दिन बढ़े लिखते आपन के ऊपर से ताकर भयंकर राग अछि
another 2 matter was filed in
सर अपन अन्य मार्ग को जानतु नहीं आगे जोटा को धरछन से as early as possible. Yes. Next part. Sorry आपन
Mr. S.N. Das name maybe.
Sri Solajanandan Das will heard Sri Solajanandan. What is your good name?
Manas Kumar sir.
But Sri Manas Kumar Swami counsel for the prisoner and Sri S.N. Das counsel for the. अच्छा आरो दिटा मैटर कोन होई छी?
Similar matter.
Same.
Delay अछि.
Date difference or the
delay अछि to?
disengage.
Same date of decision.
No, delay is there.
Delay is there. Had you filed this writ application within the period of limitation, I would have condoned the delay here. Since you have filed this writ application beyond the period of limitation, I have permitted you to file a condonation petition. Since the petitioner, rightly or wrongly, had approached this court, the appellate authority, this court trusts that the appellate authority shall liberally consider the application for condonation of delay. Is that so? Yes.
Made decision by the collector to GRS matter.
Same matter, same order.
Delay
only Annexure 9 lordship I wanted to brought to lordship's notice. Fraud is there. made by the BDO and the.
So he'll consider. Yeah, all factual aspects.
that-
I'm saying he'll
yes,
consider why should.
ମୁଁ GRS ମୋର କିଛି ରୋଲ ନାହିଁ ଘର ନଥିଲା
କଣ କରିବ?
ଗୋଟେ ପୁରୁଣା ଘରଟାକୁ
ଆପଣ ଦୁଃଖର ବିଷୟ ମାନେ ଆପଣଙ୍କ ଦୁଃଖରେ ମୁଁ ଦୁଃଖୀ କିନ୍ତୁ କିଛି କରିପାରିବିନି।
ମୋର ଚାକିରି ନାହିଁ ମୁଁ 15 ବର୍ଷ ଚାକିରି ପରେ ମତେ ବାହାର କରିଦେଲେ ଆଉ କିଛି ନାହିଁ ଆଉ ଲକ୍ଷ୍ମୀ ଆସି ଏଫଆଇଆର ଆଜି ପର୍ଯ୍ୟନ୍ତ ହେଲାନି ସସ୍ପେଣ୍ଡ ହେଲେ କିଛି ଦିନ ଭିଡିଓ ତାପରେ ପୁଣି ସମସ୍ତେ ଜିନିଷ
ସ୍ପେଶାଲ ପ୍ରୋଜେକ୍ଟସ୍ ଡାଇରେକ୍ଟର ସ୍ପେଶାଲ ପ୍ରୋଜେକ୍ଟ ସେମ୍ ଅର୍ଡର
ବୋଲ ଅଛି
ଏଥିରେ ବି ଡିଲେ ଅଛି
1/3/23 ର ଅର୍ଡରଟା
1/3/23 ର When was the writ application filed?
ରିସେଣ୍ଟ ପାଇ
12/7 ବର୍ଷେ 4 ମାସ ଡିଲେ ଲେଖନ୍ତୁ ସବୁ ସରିଲା ପରେ it is submitted that the petitioner could not approach this court earlier because of unavoidable circumstances and particularly because of financial hardship as he was out of employment. Considering the above, this court trusts that the appellate authority shall liberally consider the petition for condonation of delay to be filed by the petition. Yes. Within 1 week you have to file. Yes. No,
Item number 4. My lord, the petitioner was selected as a Anganwadi helper for Majisai Anganwadi Center and was joined on 21st of May 2012. Her appointment and joining were challenged in 2 writ applications. One was WPC 19982 of 2014, another by another person 19984 of 2014. My lord, the judgment was passed annexure 1 to the writ application. Where this honorable court was pleased to pass an order that running page 17.
Or to conduct a fresh Mahila Sabha.
Fresh Mahila Sabha. This was challenged also. This order of the honorable single bench was challenged in a writ appeal. Honorable division bench at annexure 2 at page 19 passed an order upholding the decision of the honorable single judge and directed that there must be a fresh
Mahila Sabha.
Mahila Sabha. Now, my lords, can have a look at annexure 3 at page 21.
Rotate column.
Page 21.
Yes.
ସହାୟିକା ଲାଷ୍ଟ ପାରାଗ୍ରାଫ ସହାୟିକା ପଦବୀ ପାଇଁ ଉତ୍ସୁକ ପ୍ରାର୍ଥିନୀ ମାନେ ସେମାନଙ୍କ ଶିକ୍ଷାଗତ ଯୋଗ୍ୟତା ପ୍ରମାଣପତ୍ର ବାସସ୍ଥାନ ସମ୍ବନ୍ଧୀୟ ପ୍ରମାଣପତ୍ର ଜନ୍ମ ତାରିଖ ସମ୍ବନ୍ଧୀୟ ପ୍ରମାଣପତ୍ର ଓ ସ୍ୱାମୀ ପରିତ୍ୟକ୍ତ ହୋଇଥିଲେ ମାନ୍ୟବର ନ୍ୟାୟାଳୟର ଆଦେଶ etc. they will apply and a fresh application has been called for. Your lordship categorically directed and affirmed by the honorable division bench. Only the Mahila Sabha is to be.
What does the law say regarding appointment of Anganwadi helper?
First, the application will be made, then that will be scrutinized, then they have to be placed before the Mahila Sabha. Mahila Sabha is to select. The Mahila Sabha was not constituted in accordance with law. That is why the honorable court directed that a fresh Mahila Sabha is to be conducted.
But
that means the application that was made in the year 2012, those applicants are to be only taken consideration.
You take notice? Yes, take notice.
So far the first para says, is concerned, my lord, of that particular order, input order that is annexure 3.
Justice Panigrai's order?
No, my lord. Annexure 3, page note 27.
Annexure 3.
Oh, that's advertisement.
Notice.
That says, my lord, ଏତଦ୍ୱାରା ନୂଆଗାଁ ଗ୍ରାମର ନାଖରାଜି ମାଝୀ ସାହି ଓ ହରିଜନ ସାହି 2 ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ଅଧୀନସ୍ଥ ଅଞ୍ଚଳର ସମସ୍ତ ମହିଳା ମାନଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି ଯେ ମାନ୍ୟବର ଉଚ୍ଚ ନ୍ୟାୟାଳୟ କଟକ ଓଡ଼ିଶା WPC ନମ୍ବର 19982 of 2014 and 19984 of 2014 ଙ୍କ ନିର୍ଦ୍ଦେଶ ମୁତାବକ ଆସନ୍ତା 16/7/2024 ପୂର୍ବାହ୍ନ 11 ଘଟିକା ସମୟରେ ନାଖରାଜି ମାଝୀ ସାହି ଓ ହରିଜନ ସାହି 2 ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରରେ ଖାଲି ଥିବା ସହାୟିକା ପଦବୀ ପୂରଣ ପାଇଁ ଶିଶୁ ବିକାଶ ପ୍ରକଳ୍ପ ଅଧିକାରିଣୀ ବାସୁଦେବପୁରଙ୍କ ଅଧ୍ୟକ୍ଷତାରେ ସହାୟିକା ମନୋନୟନ କମିଟି ବୈଠକ ଅନୁଷ୍ଠିତ ହେବ। So far this particular paragraph is concerned, my lord, it is completely in conformity with the order of the honorable court that a Mahila Sabha will be there. But simultaneously, it also reflects that, my lord. The
इच्छुक
person-
प्रार्थी माने बोली कह हैला
इच्छुक
Yes,
प्रार्थी,
application
माने as if they are going to consider the case of the
that was not the purport of
Yes,
the order
I
of
want to
this.
that.
All right. Shri yes, अरे बुला रे बापा. Shri S. N. Patnaik, learned AGA accepts notice on behalf of all the opposite parties.
Yes.
No extra copies are required?
No.
All right. Shri Patnaik shall obtain instructions specifically on the contention raised by learned senior counsel for the opposite, for the petitioner, that the impugned advertisement issued under Annex 3, impugned advertisement under Annex 3 is not in conformity with the judgment passed by this court in WPC number 19984 of 2014. List this matter on what do you need? On 13th August. IA. In the meantime, what interim order can we pass? Meeting in
Not to accept the application of fresias and to conduct, because when the matter, if my lord will come to a conclusion that the entire notice is contrary to the law established by this honorable court, then your lordship is to quash that.
No, but since you have said that the meeting may have already been held in the morning.
Today
morning na.
that not to be acted upon. Any decision taken in the meeting not to be acted upon.
What order shall we pass? What according to you should we pass? Otherwise I would have stayed it.
Your lordship may pass appropriately.
No, I will pass, supposing I say that operation of this order is stayed. But in the meantime, they will show that I am a purvura kordi. आगे हमर 10 टा बसिलु 10:30 भीतर हमर सरी जाई मीटिंग आगे देखो 10 को देछि.
No appointment can be made on the basis of this selection.
Yes.
Otherwise my lord will.
Yes.
It is
And my learned friend may take little pain on my behalf to intimate to the authorities.
Since it is submitted that the selection committee meeting pursuant to Annex 3 is scheduled to be held today, this court directs as an interim measure that no appointment shall be made on the basis of such selection without obtaining leave of this court till the next week. Yes.
One line, sir. Additional government advocate is directed to communicate this order, because that will.
A free copy may be provided, my lord.
Learned AG shall communicate this order to the appropriate authorities, for which a free copy thereof shall be supplied to him in course of the day.
Permitted to bring your lordship's notice, my lord. I think, my lord, there are two places.
This
So
should be
this may
related
be
to Maji
related
Sai.
only Nakaraj Maji.
Maji Sai, Anganwadi Center.
Annex 3, insofar as the same relates to
Maji Sai, Anganwadi Center.
Nakaraj Maji Sai.
Maji Sai Anganwadi Center only.
Yes.
Other may continue Amar City.
Yes, so we don't know, because we are concerned to this only.
All right.
Okay, I don't know why. I'm thankful, my lords, on the basis of my mention only this could come. Otherwise, it could not have come.
Yes, Mr. Das. Bye. Yes, Mr. Swai, after a long time.
Today I am filing an affidavit.
सुनानी ही तो लेते रहे.
ଆଜ୍ଞା
ये पूरा completely hearing ही तो
ମୁଁ ଖାଲି ରିପ୍ଲାଏ ଦଉଥିଲି ଛୋଟା ମୋର ତ ସରିଯିବ.
ଆଉ କଣ affidavit ଆପଣ ଦେଇ ସାରିଲେଣି ପୁଣି affidavit.
My lord, during his reply, my lord, he furnished
Memo और reply कौन?
no, memo reply ଟା ମୁଁ ଦେଲି ସେଇଥିପାଇଁ
इतने factual aspect को कौन court will
some documents are relevant, therefore I have given.
And how the document he has procured and what is
And
the
then the
information
affidavit
with that document affidavit itself.
All right, I will show.
You need not to show anything.
All right. Sri K.K. Swai files a reply to the memo filed by the petitioner. The same be kept on record. Yes.
My objection to that may be taken up fast. ମୁଁ objection ଖାଲି ଦେଇଦଉ ତାପରେ ମୁଁ ମୋର
There is that objection.
8th.
You have filed any objection?
No, no, just because given, no, not because oral subjection and that I'm saying.
Kuhant. Let us see.
But this case, because I have placed 50% or more than 50% of the case.
No, you said 10 minutes or 15 minutes. if I
Yes,
remember correctly.
nothing more. One document I have shown, kindly recollect my lord's memory. The EPF commission has proceeded against the institution on our application because the deduction of the EPF amount from our actual date of joining, that is 92. Some of 5 employees was not considered, including this Anita Tripathi, for whom my senior friend is appearing. She has not filed any objection, but EPF authorities have proceeded. Enforcement officer has taken note of the facts, records, and found that I was appointed and joined on 21/12/1992.
Yes.
Accordingly, EPF has also calculated the dues. 7A proceeding was completed. Fine was imposed on, penalty was imposed on 7B.
Yes.
And that order was challenged before this honorable court. Carried in appeal also because the merit petition was not attended. Appeal also, they lost it. But today he has filed it. And from whom he has collected the record, kindly see, my lord. The principal, how this manipulation at the instance of this opposite part number 4 by the principal also, kindly see. Page 4 of that affidavit, today's affidavit. Khali go to first one. Despite all these facts on record, the RTA information, so how far the RTAs are acceptable, kindly see. It is 11/7/24 my lord got it. Serial number 1. With reference cited above, undersigned hereby directed to inform you the following information at 1. The EPF of Sri Saroj Kumar Mahapatra, lecturer in political science of this college, was commenced from 1/1/95 as per the data available in the EPF office. But the EPF order is available on record. I have annexed it. That was also available before the director. And this order, the college has also contested, filed it in the court. Then how far this type of affidavit is acceptable? Kindly take judicial notice of this fact, my lord. That order is, my lord, page 75. First, 7A order. Page 75. Kindly tell it.
Yes.
Page 70. This is 7A order, my lord. The relevant file, see page 76. How the calculation was made and where from. So for SK Mahapatra is petitioner, Saroj Kumar Mahapatra, serial number 3, Panjang na lekha is SK Mahapatra, serial number 3, madam. The 5 employees were made party in the inquiry and appeared with the parata poduchtige and presented their case for proceeding authority. Lecture submitted there have been enrolled in the previous EPF account scheme for date of joining, detail of such evasion period, and this is 5 employees. Saroj Kumar Mahapatra, 21/12/92, This was the period they have not deducted. That is why EPF have proceeded, and therefore last towards bottom melon. See parallel. In respect of Saroj Mahapatra, who submits various documents stating that he was joined on the college on 21/92, the document relied upon produced are then my lord. Now therefore come 79, page 79. The finding.
Yes.
Now therefore, at case of Western Provident Commission, having regard to the factors of the case, having considered all the matter involved therein, hereby determine the following cases against Messrs. B&M College, Pariabinda, Bhadrak, on account of Provident Fund, pension, Provident Insurance Fund, consultation, administrative charges, toward Provident Fund, insurance, so and so, so and so, so and so. This is the finding. So my response submission is, this college has also contested the matter, challenged this order further, up to appeal, they have lost and money has been deposited. If the affidavit will be taken into consideration now, the PIO of that particular college is saying, RTA in respect of the petitioner is as per the EPF record. He is not saying as per the college record. He is saying EPF record. EPF of Saroj Mahapatra, so and so, this college was commenced from 1/1/95. As per the data available in EPF office, supply information by the college. He is saying EPF office has given 1/1/95. So this is blatant lie on the face of the record. And this is a false document, I would say, Mani, on the record. First of all, he cannot say about EPF office, and EPF order I have read out to my knowledge. So this type of affidavit at this juncture. And moreover, what we are concerned about, the order under Annexure 1, the order passed by the director. Before the director, this matter come up to the director in this manner. I, along with another person, filed a case because I was appointed on a 21/12/1992. I filed a writ petition before this Honorable Court for validation of my appointment under the Lecturers Validation Act 1998. Because the Lecturers Validation Act takes care of the appointment 1185 to 31/12/1992. Since I joined on 21/12/1992, my appointment comes well within the purview of the Validation Act. And the Validation Act further provides that if a person joined before 31 bar 92 and he is in the payroll of the management, then he is to be validated. It is deemed to be validated. The word is deemed to be validated under the statute. Accordingly, this court considered my case. The director has also considered, and direction was given for approval. At that juncture, this Anita Tripathi, the opposite partner of 4, came before this Honorable Court saying that that order was taken behind her back. She was not given an opportunity of being heard because she was appointed in 1993 and I was not appointed in 1992, and that is why my service would not be validated. On the Honorable Court remitted the matter to the director again to take a decision in the matter because the director has passed the order pursuant to the earlier writ petition filed by me. So director decided the matter at the instance of this Anita Tripathi, who claims to be appointed on 14/3/1993 as per her claim. But on even if considering for what was his case, I was appointed in 1993 and this Saroj Mahapatra appointed in 1994 pursuant to an advertisement or all these things. So she is junior to me and he should not be given the benefit of Validation Act. Before the director, she has produced her appointment order. That appointment order also I have shown to my law. That appointment order, he says that it is 14/3/1993. But that I have demonstrated from record. When you are coming to the director that you are appointed in 1993, onus on heavy on you to prove that you are lawfully appointed on.
But all these things have been argued.
Yes, just recapitulate. Yes.
I think it will be better if you conclude your argument.
Yes, I am just concluding that
Each and every point 1, 2, 3, 4,
yes. So she has.
And what Mr. Swai has said, what you have said.
Yes, well, I know where I have stopped also. Just where it case. So she could not produce a single scrap of paper showing that she was appointed in 1993. Rather, contrary documents were filed before the director. Director did not consider all these aspects. That is the subject matter of challenge before this one. At this point, only 2 points for first consideration is whether I was appointed in 21/12/92 or she was appointed in 1993. My case is I was appointed in 21/12/92, not in 21/12/1994. And she was appointed in 14/3/95, not on 93, as a claim. So I have shown the document against her that she has applied in 1994 pursuant to an advertisement for a lecturer post. Her application is there on record. She was selected, and when the EPF authority sent a notice to her, that document is also there. I have shown it to my lord on the other day. She says no objection to that. And EPF authority has taken note of her joining as 14/3/1995. If she was appointed in 1993, she could have rightly objected as we have done it before the appellate authority or the EPF authority. That she had not done. So that she has accepted that appointment to be 1995. So therefore the director, because all these documents were before the director, I have given my written note of submission filed before the director along with the documents I have relied upon there. All these documents again I have filed it here for ready transfer. So she could not prove her case, but unfortunately the director came to a conclusion that she was appointed in 1993. And the reason of such illegal order I have given, that is why I have made also one part deputy director who is a co-villager of that opposite partner of 4 as a party. But I think he is dead. That's what would appear. One Kishore Chandra Mahanti, OP number 6, was the deputy director then. Both of them belongs to one village. That is why she could have managed that. That's my allegation, my lord. That is something different. And this is the order I am under challenge. So now I have. That is why I am submitting that this affidavit at this juncture with these facts and moreover by the college authorities should not be. And what are the documents where I have stopped it, my lord? I am just starting from that. these college authorities on various time, there are various principles, because the manipulation, whatever it is there.
It was said incumbency of principles that you also said.
Yes, I have stated.
Number 14, Ananta Das.
Ananta Das was the principle. I have shown it from the calendar. Well, now there was also another principle. He has, his document are also filed here along by me. He has filed a report to the director at page 108. Thereafter, Ananta, page 107, I have shown, my lord. Ananta was in incumbency chart. He was continuing from 8/12/92 to Paisat Choranabel. The incumbency chart of the in the calendar, college calendar. Page 107, I have given, my lord. Because the allegation was the Ananta Das was not the principal, then how could he appoint you on 21/12/92 when he was not the principal? But this is the document to prove that Ananta Das was the principal. So now, my lord.
108, this document is.
107 ne chaditile. 100.
No, 108, that is somebody else is the principal. RB Naik is.
No, yes, that is Ananta Naik chapter I have argued. From this I will show, man. What he says, another principle. Because these college authorities and one particular head clerk has manipulated all this cash book, appointment order, all these things they have manipulated. And the resolution book they have torn out, find some typed copy of the resolution here on the before the director, all these things. So now this particular principal, subsequently who has come, he has also written a letter.
It does not bear any date.
Yes, sir. Year. Memory date पकई देइछ अछि पेज 114 रे 10/12/2001 रे अछि डेट से मेमोरी डेट देइछ ए ऊपर डेट पर मेमोरी पड़छ
Yes,
my lord, only what he has written, subject is chaotic situation in the college administration because of irregularities committed and fabrication of record by ex-principal N.R. Jena and DDPI PC Malik. This is the allegation he has made to the Director of Higher Education. This is a letter. And skipping all these points, what relates to me, my lord, in that letter, that I will show. Page 113. And page 113, para 11 and 12. Man. These two paragraphs relating to the petitioner and opposite party. Considering the representation of Sri Saroj Kumar Mahapatra, lecturer political science, 4th post, Miss Monika Naik, lecturer in sociology, Sri Tapan Naik, lecturer in commerce, 3rd post, and Sri Mrutyunjay Narayan Das, lecturer in public administration. I inquired into the matter and reached at the conclusion that there is genuineness in the claim of the lecturer concerned. It is also found that from the college records that honorarium period of service have been regularized by GB resolution number 40 dated 27/3/98, but due to the negligence, suppressive and corrupt nature of the head clerk, the proposal file has not been submitted before the DHE in time for validation of the above persons. The present situation is not congenial for me to put forth the proposal, as because there is no governing body, so an order may kindly be issued as early as possible to send the proposal and enable them to get their service validated. 12. Considering the allegation, application of Sri Saroj Kumar Mahapatra, lecturer in political science, against Miss Anita Tripathi, I made a deep investigation into the relevant record and found that Anita Tripathi had joined in the college on 14/3/95 as a lecturer in political science by the appointment letter number 1105 dated 14/3/95. Same is resolved by resolution number 33/94 dated 15/12/94. It is also revealed from the college acquittance that Srimati Anita Tripathi has managed to receive salary from 22/12/93 to 13/3/95, which is prior to her present date of joining, that is 14/3/95. Sri N.R. Jana, ex-principal, has ordered the accountant to disburse the above salary to Anita Tripathi, Srimati Anita Tripathi, mentioning the decision of the GB resolution 38/97, order dated 8/8/97, item number 8, but no such resolution is found in the resolution book. So the first service period may be cancelled to settle the matter. So this is with regard to this person, another principal has written. So now, my lord, then another letter of the same principal on page 115, Ancestral 28. This is with regard to validation of my service, and he has confirmed it that my appointment, page 116, the last note, one paragraph. Again, considering the representation of Saroj Kumar Mahapatra, political science, and Tapan Nayak, election commerce, the then GB of the college to decision to treat the date of joining of Sri Saroj Mahapatra, lecture political science, as 21/92 instead of 29/94, and Sri Tapan Kumar Nayak in commerce 21/92 instead of 99/96 in its resolution number 40 dated 27/98. Kicking the above, I came permitted to submitting the necessary record for approval of the staff member early date and applied. So now, a counter affidavit was also filed before this honorable court by the same person in WPC 6053 of 2005, filed by this Anita Tripathi. There also, he has placed all these facts on affidavit before this honorable court, accepting my appointment to be 21/92 and her appointment 14/3/95. But the court has remitted the matter to the director for consideration, again, by giving opportunity. This is it, or affidavit before this honorable court by the principal. Now, the two resolutions in this particular case, resolution number 30 and resolution number 40, submitted by me and annexed here with, I have shown it to my lord. All the resolutions of this institution I want to submit, my lord, are handwritten. All the resolution of the institution. But what was filed by the opposite part number 4 in this honorable court are two typed copy, where there is a manipulation. And those are the true copy attested. But the documents I have filed, this bears this resolution signature of the principal, president, and other persons. Those are there.
Yes.
These documents are at there. And I have also given a document to show the resolution, the governing body in a resolution which is not in dispute by her. She is disputing 30 and 40. But dividing those two, another resolution number 45 of 1799, page 141 में कर लीजिए, 141, annex 31.
Yes.
My lord, this is the resolution. The photocopy, signatures are there. My lord, only one part, page 142, resolution number 5. The seniority intercept between these two persons have already been decided by the governing body in this resolution, taking note of the facts. What does it say, my lord? Page 142. As regards to representation of Sri Saroj Kumar Mahapatra, election political science, the meeting today verified the records available in the office and arrived at a conclusion that Sri Mahapatra is holding the 4th post in the political science and Anita Tripathi is holding the 5th post. On proper verification of record, as per the judgment law of this honorable court, in Sashikanta Mishra's case, my lord, the governing body is the authority to decide the intersectionality. And then, on the verification of their record, they found me in this resolution that I am senior to Anita Tripathi. That sufficiently proved that my appointment is 21/12/92 and her appointment is 14/3/93. I have already demonstrated on record that at any cost she cannot be appointed in 14/3/1993 because the order of appointment itself in a letter number date which bears something else. Not yet. This is a point. And the payment part and all these things I have shown, my lord. I will not take much time on this. So this resolution, she has never challenged. This 45, because if this is the resolution wherein you have been declared junior, so she could have challenged that.
Yes.
And this is a resolution also kindly similar. This is also handwritten. Although 30 and 40, I filed it, and I said 3 and 15. All these are handwritten. All the resolutions. But what he has filed is the resolutions. If my lord wants to see.
Yeah, all right, that point is taken.
Yes.
Yes.
That is all that typed. And there is a manipulation in typing. And what she has only harped upon the entire case against me, that also I have to, that I along with 31 others, a group of persons, filed a writ petition, that is OJC number 5.
That has been, that you have already
Stated. That is the only point, if at all,
right.
rails against me, that you have filed a case stating that you are appointed in 94. But my submission to that is, though I have filed the Voklatam, I have not given him any, that the case was withdrawn.
I have taken note.
Mine.
I have taken.
That is the
All right.
And all these resolutions where I have only given, because he has, after filing this, he has filed many affidavits. Till date, he is filing, she is filing affidavits after affidavit. Therefore, I have filed also to document to show what the source of receipt of this resolution. Because if I am submitting a resolution, he is submitting some other resolution, there is a conflict. So this to avoid the disputed fact, I have filed document to show in an additional affidavit that the two of the members of the governing body, because their practice is they have circulated the resolutions amongst the members, and those two members I have requested them, because they have the copies, they have given me the copies and I have filed it as a proof here. And one more submission, it was also made since we both had got block grant in the meantime. So therefore, this gratinate part, I cannot claim it. And I have accepted everything. But kindly see one page, page annex 36, I have given. Before receiving this, I have received it with objection. Because what is there? 262. I have received the block grant because I was not getting anything. I have continued since 1992. I have received the block grant without prejudice to my claim in this case particularly. If I succeed in this case, I am to get validation benefits.
Where is it stated that without objection?
With 262, my lord, got it. 36.
Yes.
Yes, this original is there, my lord. I have given. I will give.
That's all right. 262.
Yes, application. Respectively, I beg to state that I, Saroj Mahapatra, son of so-and-so, I received the amount of salary without prejudice to my claim in the WPC 1246 of 2009.
That is annexure?
It is 36 additional affidavit.
Okay.
Objection to the additional affidavit filed by document number 4. I will file it.
No, I got
it. This is the I have sent it also by registered post to the authorities, to the principal, to keep a record. Registered post, I have received the money of block grant only with objection. So it cannot be used against me, or it cannot be estoppel. Because the writ petition is of 2009. Block grant come in sometime in 2013 during pendency of the case.
Sure.
Only for my survival, I received it.
So that's all?
My lord. What? Another document, my lord.
Time serial.
No, more time serial. That particular principal has written a letter that is there. She has written a letter to the director and government. Kindly transfer me from this institution because there is huge manipulation. That letter also he has disclosed what are the manipulation, including one of this nature. So that is also a letter that bona fide of that particular person. That if that letter is there, I will, my lord. Additional note.
All right.
So
we finally conclude this matter.
Again? Yes.
Whatever you have said in the detail.
2-line reply.
Reply.
My lord has already seen how much time he has taken for doing reply.
So that is not the way to argue the case.
No, I am not.
I am the petitioner. I am
anything to you.
Stop saying
Only 2-line reply.
2 line. Kunal?
My lord, much has been said about those letters and all these things. My lord, may kindly see one document that is at annexure V/4 of my preliminary counter affidavit. But at that very person who has written all these letters, he has published my lord, published a news. He published a notice in the newspaper. My lord, Sri Radha Vinod Naik, my lord, got it. Page 55. Internal page 55, annexure V/4 of my first preliminary counter affidavit. A notice is there that was published in a newspaper.
Samvad?
Yes, Sri Radha Vinod,
Annexure L/3.
that is L na?
3 एक दूसरे से उड़ो तो 3 एक दूसरे से आ रही
It
I Radha Vinod Naik.
yes, I Radha Vinod.
Whatever documents, letters, affidavits.
Yes. But this is the document. So this is my answer to all these documents which he has shown.
Yes.
This is number one. Number two, well, three persons, the present petitioner, one Tapan Kumar Naik and one Mrityunjay Narayan Das. These three persons who were appointed in 94, 94 and 96,
Application.
filed a writ petition.
I have already said.
But I have already said. And this honorable court has already decided one matter. My lord, may kindly see, I have given that, I have also placed that order. My lord, may kindly see my memo. That memo was filed on 14/5/2024. My lord, he challenged the governing body challenged the order passed by the director directing for validation of his appointment. My lord, may kindly come to that memo that is annexure.
मेमोरी वाले से पे मेमो तो देना
नहीं मेमो दीजिए मैं आपको कॉपी दीजिए
मोबाइल धरचे नो
आगे कॉपी दीजिए annexure G/4
जा देचन देच
आगे दीजिए अपन को बना करियो annexure
मोना को करी दे
मगे आगुरु प्लेस करथिले एटा annexure 4
Annexure G/4.
annexure G/4 AG/4
Yes.
well your lordship may kindly see in that writ petition the order dated 18/4/2005 passed by the director was challenged. That is relating to Mrityunjay Narayan Das. Mrityunjay Narayan Das, he also claimed like that of the petitioner that he was appointed in 1992 and his appointment comes under the Validation Act of 1998. So therefore, my lord may kindly see the order that is at annexure 4, that order passed in his favor. My lord,
Yes.
last but one paragraph.
Yes.
On verification of original GB resolution book of the college, it was found that the above resolution, that is GB resolution number 30 dated 17/7/93 and 40 dated 27/3/98 are missing and have been turned down. Principal BNMA College, by his office letter number such and such, addressed to the undersigned, has stated that the above two resolutions are missing, which seems to be intentional with an aim to harass Sri Das. In view of the above premises, it is clear that the applicant Sri M.N. Das, Mrityunjay Narayan Das, lecturer in public administration in the second post admissible to the college, was appointed by the governing body of the BNMA College Padiyabinga and he joined his assignment on 21/12/92. He is in receipt of monthly salary from the management till date as verified from the college records. Thus, the case of Sri Das is to be validated under Orissa Aided Educational Institution appointment of lecturers for Validation Act 98 as he is eligible in all respect being appointed with requisite qualification. But this order was challenged by the governing body by filing a writ petition that is WPC number 9101 of 2005 and that order I have annexed. I have given a type copy in bold letters. My lord, page 18 of that memo. My lord, may kindly come to page 19.
Yes.
According to the learned counsel for the petitioner, the writ petition being OJC number 6101 of 99, that writ petition has been withdrawn by the petitioners as would be evident from the original record of the said writ petition. It is evident from the pleadings made in OJC number 6101 of 1999, especially in the paragraph 5 which is being reflected herein below.
My lord, your lordship may kindly see, there are a number of petitioners. The petitioner number 2 was Mrityunjay Narayan Das. The petitioner number 2 was appointed against the third post of, that is, should I get there?
That relates to somebody else.
No. That relating to the same. My lord, may kindly see my preliminary affidavit.
That letter I have.
देखिए मैं तो नोट कर लिया बाकी आगे नोट कर दे
That letter-
आपको खाली टिक जस्ट कर आप मेरे और लिखिए नहीं टिक मतलब I'm not making an inquiry sir well no this is a subsidiary I have given enough relating to that writ petition I will go through sir I will go through each and every document and according to my understanding I will pass a judgment one line your lordship only one line your lordship kindly see टिक आ गया अपन निजे कहउछन पूरा अपन पैसा लेनी 2 घंटा My lord, may kindly come to petitioner. What do you want to say? Tell me the. My lord, in that case, it has been held, categorically held, that since they have suppressed the facts, and in that writ petition, they disclosed that they were appointed in 1994, one was appointed in 1996, so their appointment does not come under the validation act. That you have said, I have already taken it. I have taken it. And my third submission before your lordship. Mr. Swine. EPF Act is not applicable. That is also have taken. But section 16 of the and EPF rules.
आप इलेक्शन तो बोलो उसे लेटर पाई गई जो कोई पाऊ नहीं बोली प्रिंसिपल बड़े एनेक्स 33
Annex 33 बेलो से कागज तो बेलो
पेज 215 ଆପଣଙ୍କର କଣ ମ
ନା ଆପଣ କଣ ମାନେ
ପୁଣି ଆପଣ ତାହେଲେ ବି ସାବନ କରିବେ ମୁଁ ଖାଲି ଯେତିକି କହିଥିଲି
EPF rules is concerned that came into force in the year 2016. I have shown that rules to your lordship. Sir, I have completed it. I am done.
that test
Hearing concluded, judgment is out. Sir,
215
फिर Annex 33
month
नहीं सुनते
ट्रांसपोर्ट टाକୁ कैंसिल କରିବା ପାଇଁ ଲେଖିଛନ୍ତି with the finding से गोटे लाइन भी लिखଛନ୍ତି against this Anita. Similarly, with the help of the fourth acquaintance register, lecturer Anita Tripathi has begged her appointment from 14/3/95 to.
And the other writ application, Mr. Swine, for implementation. For implementation. It depends on the first. And all these three have accepted the position that relating to their date of joining, that is 94 and 96. All right, yes. Next item. Last I will file it in note. Yes. No, it should not be lengthy. As lengthy as your argument.
I filed the date set. I'll just ये कितने दिन I think
Yes. Your lordship may grant me 7 days time. Yes. Note of submission within a week.
matter.
Where is Mr. Patnaik?
He said that I'll have a cup of tea and come also. But your lordship may permit me. This is going perpetually to.
I know, and today I'm going to close it. Anyhow, I just wanted to know the date on which the college came into the granted date fold. That was the only thing required to be.
And on the last occasion, I was directed to produce that original file.
That was already produced.
Yes.
And State Council files is original case according to the appeal before the director. Same be also kept on record. Record to original file of the director.
Sir, କହିଥିଲେ ଯେ ସେଟା ମୁଁ ଟିକେ ଦେଖି ସାରିଲା ପରେ ଆପଣ କହିଥିଲେ
देखिए ये चिंता
ମୁଁ ସେଟାକୁ ଫ୍ଲାଗିଂ କରିକି ମୁଁ ଆପଣଙ୍କୁ ଦେଇ ଦେଇଥିଲି ଆପଣ କହିଥିଲେ ଦେଖିବେ
हाँ मतलब देखा सेटल देखिए आप
On the last occasion noted, an appointment letter issued by the secretary of the governing body of Koptipada College. The same was shown to the secretary of the governing body present at the hearing, who confirmed that it was issued by his predecessor. Secretary of the governing body, however, took the stand that the governing body had appointed Ramakrishna Mahakur, writ applicant in OGC number 1481 of 1996, as PT of the college to join on 15/11/86. In a bid, your lordship, this is important, in a bid to resolve the controversy, the Secretary Council of Higher Education, Secondary Education, Odisha, was requested to furnish the copies of the staff list received from the college in question from time to time. In the staff list furnished on 7/11/1987, 13 SK Mahanti was shown as the PET. In the staff list given by the college on 13/5/89, the present petitioner was shown as a PET with HSC and CPA qualification. On verification of the records, it was noticed that the name of the petitioner finds mention as PT of the college. The petitioner also produced documents in support of his having acquired CPA qualification in 1987. However, in the staff list furnished on 21/3/1993, Sri Ramakrishna Mahakur was shown as the PT of the college minutes. In paragraph 4, small Roman 4, they say that Sri Rangadhar Paikrai is the first qualified PT joining the college and to be reckoned as such, of which no exception can be taken. This order was communicated to the petitioner and so on, but that's not important. The fact remains, my lord, that in 89, they had sent my name and there was, I had shown your lordships, that there was also an admission. In the counter affidavit filed, my lord, there was also an admission. Now they say that I'm a total stranger to the college, my lord.
I'm closing it.
Sorry,
I'm closing it.
your lordship will close it. Your lordship will only take note of 72. Page 72 is the part of the counter that's annexure B/4.
Yes.
I'll just place, my lord, the last paragraph, my lord. On the other hand, your lordship got it?
Yes.
On the other hand, the name of Sri Rangadhar Paikrai, whose qualification.
You are Rangadhar Paikrai.
I am Rangadhar Paikrai. IACPA appears in certain documents. Indicates that fact that he has joined on 1/12/88. This fact of joining is imaginary so and so, so and so. Then 3 lines down below, and he was given this instruction. Your lordship will get it? And he was given this instruction, keeping in mind that the junior most will be appointed and adjusted in the +3 college in future, when the +3 college will be opened. In other words, the secretary wanted his name to be recorded in some places, as he was.
No, but actually, this is what Mr. Patnaik had argued also.
Malad,
on that day.
Malad. And your lordship would see what is important, my lord, if your lordship would, the name had been sent to the CHSC in 1989. And the principal, my lord, he also said that it has also been sent to accommodate him in +3 college in future. The secretary had made this arrangement, so and so, so and so. Then the last paragraph. Furthermore, I'd like to submit that there is no clarification, so and so, so and so, so and so. Sri Mahakud as PT and sending the name of Sri Paikrai in place of Mahakud as PT. So where it was sent, my lords? He stops short of saying that it was sent, but he doesn't say where it was sent. So in my humble submission, this particular sending of names admitted by the principal, read with, my lord, the counter affidavit filed by my lord, would be amply clear that in 89 my name was sent to the CHSC, my lord, showing me as a PT. And the fact remains, my lord, that at that particular relevant point of time, Sri Mahakud was sent for his CPA training. He came back, joined in 1990, and then the problem began after his qualification. And your lordship would appreciate, my lords, I have also annexed the qualification of the present petitioner and this at page 6. He has acquired his physical training qualification in March 1987, much before Mr. Mahakud.
All right.
That's my humble.
Both of you give a note. Give a short note.
Notes, I'll complete with this note, sir.
Yes. Yes. No, I wanted you to give a note. But today I'll close it.
Malad.
I'll
Malad.
grant opportunity to both parties to file a short note.
Malad.
All right.
Malad.
My lords, the entire things submitted by announcement is without records. Only I had been directed by my lords, produce the records, and I have brought all the records for the kind perusal of my lords. The fact, the admitted fact, and the undisputed fact is that this OP number 6, myself, I am for 4, 5, 6. 4 is governing.
I know. You have already argued, Mr. Patnaik.
Yes. The 6, OP number 6, applied on 20/10/86 for the post. 21/10/86, he was selected. 30/10/86, he was appointed. 15/11/86 is joined. It is undisputed and crystal clear, the records that I have attached to this, and he has not said no to this. But on the other hand, my lords, petitioner says to have been appointed 1/1/87. But the entire records I have brought, under what circumstances the petitioner was appointed. There was a selection.
I know, you have what?
I stood first, he stood second. There the secretary wanted to take to satisfy both the sides that as you have stood first, you were appointed, and I made an application for going to CPA training. During that period, my lords, importance is there, but during that period, he was directed to join it. This much. Whatever records have been attached to by him is absolutely false. Absolutely false.
But with great respect, I take objection to this. It is his counter which I was placing, where this particular document of inquiry by the principal on the query of the director was given. And he says it was sent. He says I was accommodated. He says all the mischief was done by the clerk, his concern. He says, my lord, this was done because in future, if my name is shown in the register, I may be accommodated in +3 college. He also admits, my lord, I am the first qualified PET, my lords, in the college. And my learned friend, my lord, when I'm placing this counter, he says it's all false. My learned friend appears for the governing body. My learned friend appears for the principal. My learned friend appears for the private opposite party. So all the records are with him. Whenever your lordship calls for the record, he says it's destroyed. With much difficulty, I got the counter, my lord, fortunately, filed by the state. Now my learned friend says, in the interim, as if it's a temporary appointment, ignoring the fact that the governing body has, in a resolution passed, appointed me. My names were sent in the payslips, even though I was not allowed to sign. A particular scale of pay was, it's not a scale, a particular amount was shown that is payable to me, my lords. It was his document which was submitted last time, my lords, produced by the state also. And now my learned friend is making an acquisition. It's all false, my lord. I'm sorry, my lord, with this authority, my lord, these things are not acceptable.
I am afraid of making any further submission.
Your lordship,
because of an attack of my learned friend.
No,
when he was arguing the case, I remain silent.
It's unpalatable, unfortunate that you're making a statement.
Mr. Kara,
that it's all false.
Mr. Kara, please. I'm closing your I'm
placing your document, then now you say it's all false.
No, it's not.
I have not submitted any document of mine.
I have.
Please show your counters.
The non-Mr. Kara, I am producing all the records.
File a written note.
Minors may kindly have.
Please may file their note of submissions and member citations if any within a week.
I have committed. We entered from the date of establishment of the college very late. I am submitting the teachers' acquaintance registers and non-teaching acquaintance registers.
Shri B.K. Patnaik, Learned Counsel appearing for opposite party numbers 4, 5, and 6. Files the original.
Yes, original. The teachers' attendance register.
Teachers' attendance register.
Acquaintance register. Resolution book. Resolution. These are the records from the date of establishment till date.
From the date of establishment till date. Hello. Same be kept on record.
And the last occasion, my lords have directed me to produce the record indicating as to when the college became aided. I am showing, my lords. I have annexed it. I am showing it to my lords. This is 107 that is attached to the counter.
Just give the date.
My lords.
Date
my lord, that is a 7/5/10 dated.
Further submits that the college came into the granted port from
7/5/10.
7/5/2010. Came into the granted port from 7/5/2010. Yes.
That's all. That is annex of F/6, my lord. I have attached F/6.
All right.
And the college got aid with effect from 1/6/94. Where the petitioner is there, that I was annexed it. That is annexed, my lords.
That I will go through.
My lord,
give it in your note. I will go through. Give it in your note. Yes.
Records I have given that not a single day he was there.
All right. I have completed it.
But now he is shouting that he has done everything.
I am calling out the next matter. Item 7. Item 7.
Matters will submit it by
note within a week.
Your lordship, I've also seen the government record. No?
Yeah, that is there on record. I have already taken note of
register.
After disposal.
After disposal, I will All the original records will be sent out.
Acquaintance register has also been submitted by my learned friend.
Yes, I will go. I will go.
Obliged.
And my lord, so only one sentence, my lord. Acquittance register, review stub is there, but his name is not there. He has not signed it.
Yes, item 7. Item 7.
Lords will see the last order and the order
So
prior
the
to
type
that,
of
25th June 2024.
You had submitted some application under the RTI Act.
Yes, I had required information under the RTI regarding the status of the university. But on the same date, my learned friend, they brought out some errors in the affidavit filed earlier.
That has been corrected. You are permitted to correct.
Yes.
I have corrected, ma'am.
So
Yes.
once that affidavit, that statement is retracted, my requirement of amendment does not arise because on the date prior to that, the matter was adjourned.
No, you had taken time to obtain some information.
Yes, but
What is that?
now they are saying that it is
It is not necessary. It is not necessary then.
not necessary,
All right.
not a deemed university. So because then my lord,
If it is not a deemed university, it is covered under the BPOT.
yes. So then my lord, there.
So what is your grounds?
My lord, my grievance was regarding non-payment of arrears of salary.
College is not appearing.
College is not.
The college is affiliated to you.
Ma'am.
So you have some degree of control.
We have already, in compliance to my letter order, we have sent a letter. That order letter I have filed along with the memo dated 7/5/2024, my lord. In spite of receipt of this memo, letter, college is not daring to appear before this court, my lord.
My lord will recollect that they had appeared, filed counter. Subsequently, midway, they are not appearing. With de-affiliation may be a very harsh, so I can.
Also, but not so easy for us to take such decisions.
No. You are also, all of you, including the state council, you are officers of the court. Now the court's order is not being complied with. So this is basically a civil proceeding. Had it been a criminal proceeding, I would have issued a non-bailable warrant to bring that man. But we are not interested. If he doesn't, Mr. Rautra, just a moment. If he doesn't reply, it means he has admitted it. Necessary order will follow.
Yes, my lord, your lords may ask any order so that we can, once lords pass an order, we got and handle, we have issued this letter.
Yes,
my
what
lord.
do you say? So you don't have to say anything in this regard. But
Not having-
as a state council, I would like to, because they have written, the Biju Patnaik University has written to the Krutika Institute,
My lord.
which is affiliated to it, on 19th of April. And they are not just responding. We will issue a writ of mandamus. We'll issue a writ of mandamus. I'll go through if you can, if you are able to convince the court that you have a case for issuance of a mandamus, I'll issue it. We will not wait for them. What do you say, Mr. Rautra?
My lord, in this case, the claim is for non-payment of 10 months arrears salary, my lord. For first time notice issued to BPUT in the year 2023, my lord. Though this is the case of 2013. Because there is a question regarding mentionability of the read petition. When the matter listed before my lord, your lordship accepted the submission made by Lord and Friend and issue notice, and I appear. In compliance to my lord's order, we have issued letter, and I have filed that letter along with the memo dated 7/5/2024.
You have said that following which the university shall be considered to be affiliated to.
Any order, the respondent of opposite part number 3 will comply the same in its letter and spirit. And because the opposite part number 1 is also not daring to listen our letter, my lord. Even though in that letter we have specifically mentioned, he will not appear and settle the matter, action will be taken for de-application of your institute, my lord. That is part of my letter.
So the question is, you issued this letter on 19th April. We are in July.
My lord.
Why have you not taken action so far? De-affiliate, and convince the court that yes, you have taken coercive steps. Why do you do the handle from the court? You have already said, well, so to redress the grievance of Rabindranath Mahanti as soon as possible. Failing which the university shall be constrained to deaffiliate the course including non-grant of affiliation and derecognition of the college.
May-
He said that.
May I pray, my lord?
Yes.
Your lordship, adjourn this matter up to 2 weeks. In the meantime, we will issue show cause for de-affiliation of the institute, my lord.
No, this court need not pass any because you have already issued a letter. You acted on it. That's all.
So,
I am willing to adjourn it.
your lordship, give 2 weeks time.
Sri N.R. Rautre, N.R. Rautre, Sri Learned Council appearing for the BPUT has drawn attention of the court to letter dated 19 April 2024, written by the registrar of the university to the principal, Krutika Institute of Technical Education, wherein request has been made to redress the grievance of the petitioner as early as possible, failing which as early as possible under the threat of de-affiliation of the course, including non-grant of affiliation and derecognition of the college. Stop. Sri Rautre further submits that the institute in question has not responded to the above letter as yet. Stop. He requests for 2 weeks' time to take instructions from his client as to if any further coercive steps have been taken against the institute for not acceding to the for not following the instructions of the university as per the letter. Let's this matter 3 weeks per time.
13th August.
Let's this matter on 13th August, on which date Sri Rautre shall apprise the court as regards steps taken pursuant to the letter dated 19/4/2024. Yes.
But I am submitting all the records in a bag
Yes, please.
and with a memo also I will search.
Already I passed that order. So order reach upon
Yes.
you'll take back after the disposal of the case. I'll pass that order. Whatever order is passed, whatever judgment is passed, the last line will be that parties are permitted to take back the original records.
List Yes.
Item 8, your lordship had directed me to obtain up-to-date instructions in the matter.
With regard to the claim of the prisoner for his appointment notionally as Shikha Sahayak.
Yes,
Yes.
that instruction I am to get, I have not got it.
Okay. Srivadas Leonard ji.
Copy of the order passed by the Honorable Apex Court, basing on which
That I have got, yes.
that will clinch the issue if you just place that matter.
Srivadas Leonard ji requests for a short adjournment in order to comply with the previous order. Place this matter on Ajela Sohol Hele. Please, 30th July. The previous order will be complied with positively.
Obliged.
30.
30.
Item number 9.
Matter relating to promotion to
Reading it over mailers. Pre-mailers taken up next week so that I can file a soft written note. Pretty better for both parties.
Do a 2009 matter, Mr. Mahapatra.
Yes, man, we have pleading it over because the subsequent development.
Pleading to over, arguments are pleading. Are we cricket पाठाड़ा अच्छी देखी?
2016 रे 18 रे से गोटे अमेंडमेंट आनिले जोतरे कि 2016 रे डेवलपमेंट को आनिले सेथिपई आ गोटे एफिडेविट दरकार हो
You filed that affidavit?
Yes. ସେ ଯୋଉ affidavit ଟା ଦେଇଛନ୍ତି ସେଟା କିନ୍ତୁ ମୁଁ annex କରିଛି 12 ହେଇଛି annexure
ମୋର ରିପ୍ଲାଇ ଟା ତ
ତାପରେ ବି ସେ ଆଉ ଗୋଟେ ଚାହିଁଲେ ଆପଣ ଦେଲେ ସେ ଫାଇଲ ବି କଲେ there before lordships in the record ଅଛି sir.
document was there but I have to give the reply that
Mr. Mahathir, let it come next week. Next week, as requested by Sri Dayananda Mahapatra, Learned Council appearing for you are appearing for Utkal University. For Utkal University, let this matter on 23rd July. Parties are requested to come ready for final disposal. नहीं पठार नहीं देखें.
Item number 11.
Pass over.
Item number 13.
Item 10 तक अर्जुन नहीं चाहिए. अच्छा. Item 11 गला. Item 12. Item sorry 13.
Item number 13.
Yes.
Lordship, kindly see the last order. Your Lordship, kindly see the order dated 25/6/2024, man. This is the matter that into draft.
Yeah, no question. You should go away from.
Yes, ma'am.
সকালে মেনশন করলেন না সকালে মেনশন করে দিয়েছিল list this matter before the assigned bench with permission of Honorable the Chief Justice.
Interim order is there, my lord, till today. Interim order may be extended.
We have also not received any.
The petitioner having already been relieved, the order relieving him and opposite by now shall also remain stayed till the next date, if not already given effect to. Because probably you said that it has not been given effect. What has happened actually?
He is continuing, my lord.
Interim order shall continue till the next date. Yes.
Item number 14.
Item number 14, and for the petitioner, my lord, for transfer of CP case number, which was filed by the.
Nobody appearing for the other side?
No, that matter was listed yesterday, but no nobody appears from the opposite party, so that's urgent to today.
We'll not wait. We'll complete it. Good.
Yes, my lord. My lord.
ଦେଖନ୍ତୁ ଶ୍ରୀ ଦିବ୍ୟଜ୍ୟୋତି ସାହୁ. You are Mr. Dibyajyoti Sahu. Shri Dibyajyoti Sahu, and counsel of the petitioner is present. None appears for the opposite party despite repeated calls. Since the matter is of the year, yesterday also there was no appearance from the side of the opposite party. The matter being of the year 2017, this is therefore taken up for final disposal. Yes.
Yes, ma'am. For seeking transfer of CP case number
from Navarangpur to Hon'Ble.
Yes, my lord. My lord, my husband has filed section 9 before the court of Bhubaneswar, my lord, in which I appeared, but it is very difficult on my part to travel from.
Prayer for transfer has been made on behalf of the. Prayer for transfer has been made by the petitioner wife of CP case number 20 of 2017.
Judge Family Court.
Pending before the learned judge, pending in the court of learned judge Family Court Navarangpur to the court of learned judge Family Court Bhubaneswar. Court Family Court 1 or 2?
Only the Judge Family Court Bhubaneswar. Here, my lord, I have annexed that page at annexure 2, my lord. The petition which I filed.
No, then there was only one court. Now there are 2 courts. So we'll transfer it to court number 1 now. Prayer for transfer has been made on the ground that the petitioner is residing at Bhubaneswar and Navarangpur is at a distance of more than 500 kilometers, for which it would be inconvenient and difficult on her part to travel to Navarangpur to attend the court on the dates fixed. Stop.
And wife has filed divorce petition before the family judge Bhubaneswar.
Divorce case is also pending before the family judge at Bhubaneswar.
Yes, ma'am.
Having regard to the submission as above and the ground on which the prayer for transfer has been made, I am inclined to allow the same. It is directed that so and so be transferred to such and such family court. 1 will cover. Yes.
Item number 15.
For item 11, bro. I was waiting outside. Item 9 was Mr. Mahanti, Aswini Mahanti's case. He went out, I came in. 11, can you take?
Yes.
Yeah, please, my lord.
Item 11
So, matter relating to appointment of Anganwadi worker. Once earlier also, this petitioner was before this honorable court. This honorable court directed the petitioner to file an appeal before the ADM, Teunchar. Appeal was filed. Appeal was heard at length, and interestingly, only the petitioner's counsel appeared throughout. He argued the case. Case was concluded on a particular day. The counsel was directed to file a written note of argument. Before that date, also written note of argument was submitted. There was no appearance ever on behalf of that private opposite party, who is present opposite party number 5 before your lordship. No appearance on her behalf before the ADM. Never, nobody appeared. No argument was forwarded, submitted. But the ATM on a subsequent date, I will show from the order sheet also, your lordship will find that total non-application of mine. It appears that on one particular subsequent date, orders have been written by the bench clerk and signature has been put by the ADM without application of mine. And she refers to some written statement filed by that private opposite party, which has never been filed. No copy has been served on us. And thereafter illegally has only narrated the case of the appellant before her. And then the case of the respondent and the report of the CDPO, Child Development Project Officer, who throughout says that yes, the selection has been
No,
done.
but Mr. Mishra, what you are submitting, if it is accepted by the court, then the matter has to be remanded again.
There is no point in remanding because his lordship.
Because you say that some written statement filed by the private opposite party has been considered, but you have not been served copy of it.
That will not solve. Again, that will go on. Even if it is considered, let us concede for the sake of argument that something has been filed and that has been taken note of. My case is that there is a particular Anganwadi center, Kundala Anganwadi center, under this particular block. Thereafter, a new Anganwadi center was created. The entire area of Kundala Anganwadi center was divided in two parts. For one part, another Anganwadi center was created. That was called Kundala 2 Anganwadi Center. Purnasai Kundala 2 Purnasai Anganwadi Center. I applied my application, submitted my application. Some other persons also submitted their applications. This present opposite party number 5, she was working in the erstwhile original Kundala Anganwadi Center as a helper. She and as regards fixation of the jurisdiction of a particular new Anganwadi center, I applied for the copies of the documents as to how you decide under Act. It is purely done on the basis of the survey made by the Anganwadi worker of the original Anganwadi center. Your lordship will find, I will point out that survey report has been given. That has been given by none other than this present opposite party number 5, who is the beneficiary, who has taken the benefit of such report. She says, as regards this present petitioner, she says that the present petitioner does not belong to the Anganwadi service.
So what is the finding of the ADM? Let us see.
She only accepts. She only accepts.
No, let us see your your appeal memo. Do you have a copy of the appeal memo?
Yes, my lord.
Please.
My appeal memo, along with my written note of appeal also given before the appeal.
No, before that, what happened in that advertisement? You were not selected. I mean, you had appeared, but in the selection process, you were not selected. Opposite party number 5 was selected.
Opposite party number 5 was selected.
Then you challenged it and ultimately.
Initially, everybody could know that illegal favor has been is being given to her.
Okay.
Because in the select list, although she has secured only 42% marks in matriculation, I possess the qualification of matriculation with 57% of marks. Apart from that, for additional +2 in qualification, I have been given 5% marks. So, but her marks were shown as an inflated figure, showing it above me. So that I brought to the notice of this honorable court in my earlier application.
Yes.
But later on, they have changed that. They have corrected that.
You are Bhanumati Dolai.
Yes,
Respondent number 2 is Nandini Naik.
Nandini Naik.
Now, one of your grounds that I find is the candidature of respondent number 2 means Nandini Dolai.
Nandini Naik.
Nandini Naik.
Madam.
Ought not have been considered since she does not satisfy the aforesaid eligibility criteria insofar as she does not belong to the service area of the new Anganwadi center in question. This seems to be one of your major plank of attack.
And I have been illegally excluded, saying that I do not belong to the service area.
Then that manipulation of marks.
Manipulation of marks, that has been corrected.
Okay. So it boils down to the question of residence, whether you belong to the residence area, service area, and whether she,
whether she belongs or not. Whether she belongs or not, that is not relevant for me. Whether I belong or not, that is relevant.
If you belong to the service area, then because of your higher marks, you would have been selected. That is your case.
Yes, my lord. That is one point. The other point is a technical point. They say that she has been chosen because she is a Anganwadi helper. She has an experience of Anganwadi helper. But my submission is that the provision in the guidelines say.
Yes, yesterday we were deciding that matter. Another matter. It has to be a fresh advertisement. If a casual vacancy occurs of Anganwadi worker and if there's a helper around, then she can only be given preference.
Around means how wide around? That is the question here. My humble submission is that in a particular Anganwadi center, if there is a vacancy,
helper,
if in that particular Anganwadi center there is a helper available with 5 years experience, then she has to be considered. There is no dispute about it. But it has been taken as an omnibus provision, as if wherever an Anganwadi helper is available.
That is not the issue.
That is not. So it has to be read.
You filed a counter.
Yes, a counter has been.
What is your counter? What is the? Let us have a preliminary. I mean, look at
that thing has been insisted. The paragraph 9 and 10 that she doesn't belong to the center area.
Who? The petitioner?
Yes.
On the basis of on what basis?
As report of the concerned Anganwadi worker and sector lady supervisor, her candidature is invalid due to paragraph 9.
Yes.
Due to her residence being not, language is not correct, due to resident of her house holding serial number 108 is not coming under the service area. That is serial number.
What is your specific reply to this?
My specific reply below.
To this, that your house holding number is 108. The service area is up to from 1 to 104. That is their specific stand.
Very specific reply to this. Originally, you will also find from the advertisement. Advertisement is annexure 1 at page 14 of the writ application.
Yes.
You will also find that the Karma Padavi Nimitta Vigyapita Anganwadi Kendra Talika. There are 4 columns. Kendra Parisara Bhukta Sahira Nama, last column. Kundala Sahira Nama Hela, Kendra Parisara Bhukta Sahira Nama.
Kundala Puruna Sahi, Pura Sahiru
Mahanta Sahi. So this is the description. There is no description like house number 1 to 104. This has been subsequently introduced in order to make out a case that only the persons belonging to house number 1 to 104 are to be considered. Anybody beyond that will not be considered. And my house number has been shown as 108. Surprisingly, you also will find that this house number, more as a 108 house number, it a code to information. What is the source of the information? No, 5 million. The candidate. You also will see at page 37. 36, 37. Conjointly, your lordship may kindly have a glance. Page 36, 37. This is the report. Who gives this report? Nandini Naik, Anganwadi helper, bracket Rahila, who is none other than OP5, Kundala Anganwadi Kendra. While working as Anganwadi helper, working in capacity of making the survey.
That is why, Mr. Mishra, I suggested at the beginning, this determination of your house cannot be done by the writ court. It has to be done, if not by Nandini Naik, then by somebody being directed by this court.
Yes.
So we can do one thing. We can do one thing. We can keep it pending. I can direct some independent person to find out. That will clinch the issue.
That is clear. I have made clear. I have given document. Your Lordship will see the house number. My house number is actually 86, 87. That is the voter list I have given.
Evidence against evidence. Let somebody.
The voter list is a public document.
Anyway, I will keep it pending. I'm not saying that I will dispose it off. I'll keep it pending. I'll ask somebody, let us say, of the rank of
RI or
video. Let the video. What do you say? Let the video find out.
My apprehension is that
They will be manipulated.
Influential person.
No, under the supervision of the collector. This court will direct the Kharavaraisi.
since it is a matter more or less relating to the measurement in land or finding out the location, better any official of the Tahsil.
No, they will do, but what he apprehends that there is also possibility of manipulation.
Maybe, yes.
So if it is done under the supervision of the collector, I don't think there should be any difficulty.
No.
What do you say?
On this score alone, that the candidate who is going to the beneficiary, she gives a report, and that.
Then what will happen is, because if you are submitting this voter identity or voter list, which shows your house
number is 87.
House number is 86 or 87. So I will have to send it back to the ADM again. I cannot straight away accept your only because it's a public document. You see, the counting of giving of house numbers may be different. Insofar as preparation.
They also should have been transparent in that manner also. They should have said that this is the manner in which we allot the numbers. No, nothing, no principle for.
So what is, there are 2 points, Mr. Das.
Yes.
First is, the advertisement is very clear. Amako Sahiru, Amako Sahi. So unless you come forward with a case saying that Sahiru, Sahi Bhitar jo area Bhitar se rona thi, she is staying in some other Sahi, she cannot be excluded.
House numbers.
House number is not relevant.
Yes.
Whether 108, even assuming that her house is 108.
Your Lordship is correct. Yes.
Still, if it comes within that area, Sahiru se Sahi Bhitar, tale, se kotha to koileni kotu.
Sahi dita Sahi Bhitar kaun sthire nuhanti.
Se kotha kotu ko jayeni.
That chhada sei jo report re joda me kohchi se karchanti sethira mate se lekhichandi ha boli ei jo page 41 your lordship kindly see
page 41 yes
nuhe boli kintu page 41 Bhanuvati Dali page 41 so
Hon'Ble Kendra Anchalaro
column 12 column
Basinda ha ba nahi se ha
lekhichandi Anganwadi Kendra ra basinda.
So irrespective of the house number,
sir,
this report itself says that
she belongs.
Belongs.
Contrary honi.
Yeah.
Kya kariya?
As your Lordship had proposed that would be better within a given particular time.
No, but this I had not seen. What Mr. Mishra has pointed out now.
On what basis?
If that report is to be accepted, this report itself says that she is a resident of the service area.
Where was there was no such requirement that one should belong to house from houses from 1 to 104. We'll
close it. We'll close it. All right. Hearing concluded.
Private party perhaps has not been heard.
No, not been heard.
Sufficient notice.
Sufficient notice.
Appear occurring to me something has taken note of, the ADM has taken note of something which has never been filed. I have taken specifically on that.
But you can do one thing, you can submit a short note.
Yes, sir.
It will not be as thick as your writ application.
No.
Only 2 pages. 2 pages.
Only, yes.
Only the points, bullet points will do.
My lord.
In fact, bullet points will be helpful. If it is too lengthy, I will have no time to look at it.
I will not make it lengthy. And one more thing about the other thing. Same Anganwadi worker, Anganwadi center helper with that I gain support of a document which I have annexed as Ancestral 12 in my rejoinder affidavit. Ancestral 12. You will see.
The minutes of selection.
Yes. Ancestral 12. There clearly minutes of proceeding, page 7 to 8. You will find. I just read out the first paragraph. Sarvaprathama Upajilapala so was the Samasya. सरकार चिठी नंबर सो अनुजाई जदि उक्त केन्द्र सहकर्मी सरकार केन्द्र सहकर्मी माने हेल्पर सरकार गाइडलाइन अनुसार योग्यता मानदंड पूरण करिथिबे एवं से उक्त केंद्र रे 5 वर्ष रु अधिक कार्य करिथिबे तेबे ताकू उक्त केंद्र कर्मी रूपे नियुक्ति प्रदान करिथिबे. So there is a very clarified position, and according to this every selection is being made. How they can say that had there been the objective been that any Anganwadi helper of any center can apply, so advertisement should have been that wide, so as to give opportunity to all the helpers. There are hundreds of helpers available. Why should there not be given opportunity?
Hearing concluded, judgment reserved.
As submitted.
Parties may file their note of submission, if any, within a week.
Within a week.
Yes.
Item 15.
My lord, on the behalf of Mr. A.K. Raut kindly taken over next week, 1 week after. And
All right. Please this matter 1 week after I spread for.
yes.
Item number 16.
Item number 16, I want BC.
Yes.
And for the petitioner in this case, as per the instruction of the counsel of the trial court, the matter has been settled. So he doesn't want to press the case. The petitioner.
Not pressed.
17.
None appears on repeated calls. Yesterday also there was no appearance from the side of the petitioner on repeated calls. It is therefore presumed that the petitioner is no longer interested to pursue this application. The transfer application is therefore dismissed for non-prosecution. Yes.
Item number 19.
It's a transfer application. Prayer is made up to transfer the civil proceeding hearing number 81 of 2018 from the Court of Law and Judge Family Court.
You are appearing for the other side.
I am appearing, but no instruction since 3-4 years.
Allow kar
But no, my prayer was by that time from Family Judge Bhubaneswar to Civil Judge Athagad, because the petitioner's jurisdiction is Bodamba. By that time, Civil Judge Junior Division, Senior Division was not there. But by the this time, it has been.
amend amend no kale kintu Athagad gote civil court achi na Athagad achi Bodambar achi
Bodambar ebe hela
Bodambar ebe hele madhya
setebele 18 nothila
oda formal amendment kar do nathi. You will allow it, but amendment next week amche oda amendment transfer application na amendment kar do na writ application itla orally kar dei thanti transfer application. Why should there be any objection? List this matter next week as learned counsel for the petitioner wants to file an application for amendment. I'll allow it on that day and allow the transfer application also.
Say that on 23rd, because on 22nd I may not.
23rd to sure. 23rd.
Item 20.
In item 20, your lordship had directed for notice through police. Instructed us to make a prayer for 7 days time because no one was found in the house.
What are you?
I for stay, my lord.
Yes, that will be considered. Why you worry? That state council requests for the time on the request of the local IAC.
IAC Ranpur PS.
IAC of Ranpur PS. For service of notice on the opposite party. List this matter on 30th July. In the meantime, further proceedings in CP number 188 of 2022, pending in the Court of Learned Judge, Family Court Nayagad, shall remain stayed. Yes, till the next date.
Item 21.
I beg your pardon, my lord. Item 17. Can I?
I've already dismissed it, Mr. Panda.
My lord, I have no instruction since last 5 years, my lord. Withdraw for the.
Oh, no instruction withdrawal. No instruction.
Public.
Item 21.
May I please, Lord? While the petitioner wife filed the TRBC application to transfer the divorce proceeding from the Learned Family Court Bhubaneswar to Family Court Bhadrak, my lord. Other two proceedings are pending.
Any chance of settlement?
No, my lord. Already mediation failed.
You were sent for to mediation. Okay.
My lord.
We'll take it up. You wanted to be transferred from Bhubaneswar to Bhadrak.
Bhadrak.
Is what you say, Mr. Nanda?
No, this has also been examined through virtual.
Virtually,
Your Lordship may direct it for virtual.
The petitioner wife seeks transfer of CP number 516 of 2023 from the Court of Learned Judge Family Court to Bhubaneswar to the Court of Learned Judge Family Court Bhadrak. Therefore, transfer has been made on the ground that another proceeding being CRP number 280 of 2023 and
one DB number 456 of 2021.
Other proceeding being CRP number
And two grounds, my lord, they have challenged.
and
DB number 456 of 2021
and DB number 456 of 2024 are also pending
2021.
2021 are pending at Bhadrak before different courts at Bhadrak. Further, the petitioner, you are residing at Bhadrak?
My lord.
The petitioner also resides at Bhadrak. It is therefore submitted that it would be convenient if the case is transferred to Bhadrak. Then counsel for the opposite party opposes the prayer for transfer by submitting that his client is working at Bhubaneswar.
Yes.
And therefore, it would be difficult on his part to travel to Bhadrak on the dates of posting of the case. Considering the submissions and the ground on which the prayer for transfer has been made, I am inclined to allow the same. As more so, as the opposite party can always appear through virtual mode. It is therefore directed that the proceeding in such and such be transferred. Further, it shall be open to the opposite party to seek permission of the court to appear through virtual mode. It shall be considered liberally and his physical attendance shall not be.
One thing, my lord, your lordship may let the divorce proceeding be there in the Bhubaneswar, my lord. It will be hard on through virtual, my lord.
Divorce proceeding?
Again.
Divorce proceeding to transfer of inquiry?
Again. CP number
516.
516, my lord.
No. Let it be transferred. Wherever the lady is, it should be transferred to that place.
No, their ground is, my lord, that since the distance is more than 150 kilometers and another ground is that there was setting from the side of husband, my lord. So virtual, she can appear through virtual.
No, you appear through virtual. You appear through virtual.
Right.
Yes.
Connected item is also, I have prayed for transfer of that 125 proceeding from Bhadrak to Bhubaneswar.
Will be rejected?
Rejected, no? I mean, we are allowed to appear through virtual.
Rejected but allowed to appear through virtual.
Rejected that can be disposed of your lordship may direct. That can be disposed of your lordship may direct.
Language.
Right.
Deeply applied.
Yes.
Item 22.
Not in time, as he can appear to.
On behalf of Advocate Modepua Mishra, the petitioner counsel, that would date such mediation continuation.
Mediation.
Mediation charge.
Mediation has been adjourned to 26/7. Report also.
The report of the mediator indicates that the next date of 15 तारीख था ना?
15 तारीख पर आस्ती 26.
अच्छा हो. It is stated at the bar that the next date of mediation is fixed to
26/7/2024.
26/7/2024. Therefore, list this matter on 6th August.
Item 23.
My lord, in item number 23, I am appearing virtual mode due to my illness, and notice have been issued in this case and returned due to insufficient address. Only mistake is that plot number is not written in the title address, my lord, sole opposite party number. So may I pray for amend the only to add the plot number in court title in the courtroom.
No. Fresh requisites be filed, furnishing the corrected.
Yes, fresh requisites will be filed. Only plot number to be added in the court title, OJT party number to show OJT party number address. Yes, I will file if my lord director. Already, if my lord of director will file the fresh requisition.
That is what I am saying. Why are you interrupting?
But the address is the address to.
Sir, ठीक just wait करना तो order टा मैं कौन डाकुची ते सुनिए.
Yes, my lord. Yes, my lord. Yes.
अपन तत्पर वाले को मुँह आया भूली गए कौन order देखी.
Apology, my lord.
मोर मन पुणी वर्तन कौन order देखी मुझे जानी पड़ने. Fresh requisites be filed furnishing the correct address of the opposite party. है ना? Within 3 working days for issuance of notice by speed post. है ना? A short returnable date be fixed. Let this matter on 13th August. Yes.
Item 24.
My lord, only plot number to be added in the court title also.
Correct address है अपन जहाँ दबा करता दे आखिर करी की दबा कौन plot number indicate करी की दबा.
Yes. Okay. Acknowledgement.
Yes.
Also directed to court below virtual court facilities available or not?
Yes.
Virtual court available facilities available or not? Last two.
Facilities are available in this court for appearance of parties virtually. And you must also thank me for that because I was the district judge and when that court opened, I had made all arrangements for that. Yes. So virtual is available. You appear virtually. Why should the case be transferred? All right. I'll permit you. You are the husband. Husband and in-laws, right? All right. The petitioners seek transfer. I will come to. As directed, learned JMFC Polsora has submitted a report indicating that facilities are available in the said court for appearance of parties virtually. The transfer application is therefore taken up for hearing. The petitioners seek transfer of GR case number 69 of 2023 from the court of learned JMFC Polsora to the court of learned SDJM Balangir. It is submitted that the petitioners are aged persons and are residing at Balangir. It would therefore be difficult for them to travel to Polsora, which is at a distance of more than 300 kilometers from Balangir, and communication facilities are also not available. Stop. This court finds that the petitioners, being the in-laws of the informant, have been arrayed as accused persons in the case. Stop. Since facility for virtual hearing is available, this court does not find any justified reason to direct transfer of the case from Polsora to Balangir. More so as all the witnesses more so in such view of the matter, the transfer application is disposed of, granting liberty to the petitioners to seek permission of the court below to appear through virtual mode. We shall be considered liberally. But there yes, this is a criminal case, so
Item 25.
May I please, Your Lordship?
25 is not your matter, yes.
Yes.
You are appearing for the husband. No,
Yes, my lord.
Here the case filed by the wife for transfer of civil
My lord, we
proceeding
have no objection, my lord, to transfer.
from
What happened to the mediation proceeding?
mediation proceeding was failed as per my
Failed.
instruction.
No, আসেনি এ পর্যন্ত?
So mediation proceeding was initiated in another matter
আচ্ছা,
by the another bench of this honorable court in your DB proceeding, my lord. His wife has filed a PWDB Act proceeding before the SDGM Jagatsinghpur that was sent for mediation.
so you agree with this?
Yes, yes, my lord, we have no objection to transfer.
Oh, see, he agrees for transfer of one.
Well,
It is stated at the bar that the mediation proceeding has failed. The transfer application is therefore taken up for hearing. Therefore, transfer has been made by the petitioner wife of CP number 314 of 2023, pending in the court of Learned Judge Family Court Cuttack to the court of Learned Judge Family Court Jagatsinghpur. Therefore, transfer has been made on the ground that the petitioner is residing at Jagatsinghpur, and therefore it would be convenient for her if the case is transferred to Jagatsinghpur as a city.
our appearance may be no virtual.
Yes, counsel appearing for the opposite party submits on instructions of his client that his client has no objection to the case being transferred as prayed. In such matter, the transfer application is allowed. It is directed that such and such be transferred to such and such court. It shall be open to the opposite party husband to seek permission of the court to appear through virtual mode. Yes.
Obligation.
Urgent copy, by urgent copy.
Urgent copy be granted. Yes.
But petitioner before my lordship is the wife, my lord. She seeks transfer of the case from senior civil judge Rajgangpur to the judge family court Kendrapada. Distance is.
My lord, I am appearing for the opposite party. I am filing my wakalatnama today. The matter may be taken next week, my lord. Today only I have received the brief.
All right. Good. Ms. Ekta Agarwal, advocate and associates have entered appearance for the opposite party by filing wakalatnama in court. Same be kept on record. Their names be reflected in the cause list. Place this matter next week.
Interim order
to continue.
Grateful, man.
Item number 29. No, item 27.
29 passed over, my lord.
28 27 28 कौन है?
Sergeant is placed to like.
की mention करता है? की mention करता है? Somebody had mentioned, so I had 28 भी से सकाले mention नहीं था? Mr. Vishwa had mentioned.
29 passed over.
कौन भी?
On behalf of Mr. Das.
All it was over.
Item 31.
Item 30, madam. 30.
Item 30. Very urgent.
Again, I got the petitioner, my lord. I have transferred to Fulbani family judge to Panjanagar.
Fulbani to Panjanagar कितना होता? It's not very far.
Little baby says to
Only
have
90 kilometers.
Only
90, 80, 80, 90.
Toto chuata achi or in Masra say they have not.
Well, it will allow it. Will allow it. Will appear through virtual board or what? You are the husband.
Petition husband is working as RI, my lord. So his part is it is.
So you will appear through virtual mode.
A virtual.
Yes, I will grant you permission to appear through virtual mode. Therefore, transfer has been made on behalf.
He is working as RI, my lord. So on each and every day he travel to his part.
Virtual mode
Again, virtual. And one more prayer, my lord. Target maybe.
Prayer for 2024 matter, why should we be targeted? Prayer for transfer has been made by the petitioner wife of CP number 12 of 2024, pending the Court of Learned Judge Family Court Fulbani to the Court of Learned Civil Judge Senior Division, Bhanjanagar. Prayer for transfer has been made on the ground that the petitioner is residing at Bhanjanagar with a small child and without any financial support. As such, it would be difficult on her part to travel to Bhanjanagar on the dates of posting of the case. Correct. Learned counsel appearing for the opposite party opposes the prayer for transfer on the ground that his client is working as a RI and therefore it would be difficult on his part to travel from Phulbani to Bhanjanagar on the dates of posting of the case. Para. Considering the submissions and the relative inconvenience that may be caused to the parties if the proceeding continues at Phulbani, this court is of the view that it would be more inconvenient to the wife than the husband. Stop. The transfer application is therefore allowed. Moreover, the petitioner can always appear through virtual mode by seeking necessary permission of the court. The transfer application is therefore allowed. Virtual mode.
Item 32. May it please your lordship, I am appearing for the opposite party wife. I received the case file on 12/11, so I will be permitted 2 weeks time to file my objection or counter affidavit.
What counter in a transfer application? Can it be settled, Mr. Ratha? Can it be settled?
That is what I want.
Yes.
It's an attend miller, nature of job, and both are overloaded with their work millers.
Both are doctors?
No, one is doctor, assistant professor in some hospital. The wife is a assistant professor in engineering college at Borum.
Okay. Why not have a mediation? Yes, what do you say? Yes, I am asking you, sir.
Yeah, mediation, both parties are agreed to for mutual divorce, sir. So, conciliation has failed.
Mediation decide mediation decide then you will file your with the transfer application is not, it will become infructuous.
Yes.
If you agree, nobody is forcing you. If you don't agree, it doesn't matter. I will take up the transfer application.
That is for betterment.
What do you say?
No, we agree. My lord.
You agree for mediation? All right. Mediation code husband. Bhubaneswar. No, husband is at Bhubaneswar. The lady is at Barampur.
Yes, that I
want. Barampur, so Barampur may.
We'll do it at Barampur Mediation Center?
Yes, that can be done.
All right. We'll direct the DLSA Barampur to.
Yes.
In course of hearing, it is stated at the bar that the dispute between the parties, the nature of the dispute between the parties is such as can be attempted to be resolved amicably through the process of mediation. In such view of the matter, let the records be transmitted to the Secretary DLSA Ganjam at Barampur, who shall appoint a mediator from the panel. The parties are directed to appear pursuant to notice received from the mediator and to render full cooperation in the mediation proceeding. Let this matter on 10 September. 10 September.
Yes.
The adjournment.
Okay.
Item 33.
May I please, your lordship? All the petitioners are already surrendered and the surrender certificate has been filed, my lord. Your lordship has granted him interim bail twice for a period of 2 months and 1 month. And thereafter he has surrendered himself on the date fixed, my lord. And now the petition is for disposal on merit, my lord.
the total offense under section 20B, 2C of 25 and 29 of NDPS Act, my lord. The petitioner is in custody.
Earlier rejected?
Earlier rejected by Justice V. Nursing, my lord. But because of the fact that prior to that, your lordship has allowed the bail application for co-accused, so the matter has.
I have never heard this matter earlier.
No.
But this name seems familiar. Yes, D. Dora, Salyadu, Vilesu Dora.
The guardian driver.
No, but name seems familiar. Probably I may have come across this name in the connected application. Have I not disposed this?
Connected application.
Yes, Prahlad Dora I have disposed of.
ଆପଣ ଦିଟା ପୁରା ଇଣ୍ଟରିମ୍ ବେଲ୍ ତାକୁ ଦେଇଛନ୍ତି ଦିଥର ଆପଣ ଦେଇଛନ୍ତି ଥରେ 2 ମାସ ଥରେ ମାସେ ଏକ୍ସଟେନସନ କରିଛନ୍ତି ମାସେ 2 ମାସ
18/10/23 then extended
so କଣ ହବ
22/12
ଆଉ କଣ
ଆୟା ଡ୍ରାଇଭର ଟା is not the drive.
Last time I was not inclined to extend the period of interim bail, Mr. Mahapatra. I rejected it also.
Yes.
ये हबनी मैं दिथर देली जेतिकी पाइले
नहीं ऑन मेरिट
जेतिकी गंगा गले सेतिकी फल पाइले
4 वर्ष रहिलाणी
जेतिकी गंगा गले सेतिकी फल पाइले आ कोन करा जे
4 वर्ष रहिलाणी योर लॉर्डशिप हैज ग्रांटेड बेल टू द accused person.
रेगुलर बेल
हां ए रेगुलर बेल ए केस रे आपण खाली सेतरे ताको बेल दिछथि बिकॉज़ he
was on the statement of the co-accused. That is why he was granted bail. Yeah, what is the you will do one thing.
Owner गाड़ी रो होची
Mr. Mahapatra will do one thing. It will help you. We'll do one thing. We'll call for a status report. So we'll look at the status of the trial, and if he has stayed in custody for more than 4 years, then obviously he is entitled to pay for bail.
Depending on 4 years 7/9/2020
7/9/2020 more than 4 years again.
No, not more than 4 years out of
7/9 sorry
7/9
status report
yes Leonard the court below is directed to submit a report regarding status of the trial. This matter on 30th July. This order will be communicated to the court below forthwith.
Item 34. The petitioner has filed fresh IM, my lord, 857/6 of 2024 for interim bail, my lord.
This matter was there yesterday.
Yesterday. It's all.
This is the disposed of matter.
Yes, ma'am.
And the reception is on 17th July. मैंने कल ही तो अपन चाहूँ 2 मास बेल
यार तब मार को देखो करके
नहीं 2 मास बेल कौन हो अपन रिसेप्शन गोटे दिन अटेंड करिए
मार देह टिके खराब
कोड लिखिन अपन
पैराग्राफ 4 रे लास्ट
आजिरा
and दी टाइम कोइंसाइड करिला नहीं रिसेप्शन और ये you have already surrendered.
Yes, ma'am.
Surrender to custody.
Who surrender?
Bharat.
What's silent? IA 856 of 2024, prayer for interim bail has been made by the petitioner, who has recently surrendered on 12th of this month. The reason cited is that his brother has married on 14th and the marriage reception is to be held on 17th of this month. Further, his mother is suffering from several old age diseases and requires treatment. Learned State Council opposes the prayer for interim bail. But fairly submits that, considering the grounds cited, the court may pass appropriate orders. Considering the submissions and the grounds cited, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 3 weeks. Yeah, IA is disposed of.
Item 35.
May I please? This is a case under section 468, 479 and section 6 of OPID. In the principal case, my lord, this is the remand case, my lord. In the main case, my lord, your lordship granted for 4-month interim bail, my lord, which has not been expired, my lord. And in the present case, my lord, interim order is already expired. 4 weeks granted. Unless this
is an anticipatory bail matter.
No, my lord.
Regular.
Bail.
What happened, Mr. Mishra?
In the principal case, my lord. Main notice. This is the remand case, my lord. In the principal case, my lord, your lordship granted 4-month interim bail to the petitioner, my lord. That is the main case, my lord.
Yes.
Yes, my lord. In this case, my lord, they have been remanded, my lord. In this case, your lordship granted 4 weeks interim bail,
Then?
which is expired on 29/6/2024.
Yes.
And I file an extension of interim bail, my lord. Unless interim bail is granted, my lord.
No, each case,
My lord.
I have not granted any.
Yes, my lord, your lordship granted.
Where is the by order dated?
This is the order.
नहीं केते order date खाली बंद होई बाहर कर देबी
मु देई दी सेठी
ए जो 8127 of 2023 रे ओ से 9510 ର order टा हिच तमन Oh, considering the fact that he was granted bail in the original other application,
my lord, that is the whole ground.
Now what has happened?
Now, my lord, yeah, that the principal case, my lord. In that case, my lord, interim order has been till in force, my lord.
Yes.
In that case, 4 months was granted interim.
4 months.
In this case, my lord, 4 weeks only granted.
Acha. So when is that order going to expire?
6 September.
6 September. Shri Tukuna Kumar Mishra, Learned Counsel for the petitioner, submits that the petitioner was granted interim bail for 4 months, 4 weeks, as per order dated 15/5/2024. However, he was also granted interim bail for a period of 4 months.
4 months.
As per order passed by a coordinate bench.
By your lordship.
As per order
In both
passed
the case.
by this court in connection with another case. That is BLAPL number 10686 of 2022 and BLAPL number 9032 of 2023. It is submitted that the 4-month period is due to expire on 6th September. Na kete?
Yeah, 29th. Yeah, 4 month my lord is going to be expired on 6th September.
On 6th September.
6th September.
It is therefore prayed that unless the interim bail granted in the present case is extended till the said period, till the said date, it would lead to conflicting orders, as the petitioner would have to surrender to custody despite being granted interim bail in the connected case. Then State Council. The copy.
Copy. Inform me copy.
Sure. Considering the submissions and the peculiar facts of the case, the interim bail granted by order dated 15/5/2024 is extended till 6/9/2024. Till 6 Jan?
6 times.
6. With all other conditions remaining intact.
I will also intimate to the council. Okay. Deeply.
I don't know. The previous item, urgent certificate.
Urgent certificate. Sheti Thavan.
Only modification, next item. But I am not watching.
Modification order ketra achi? Bail order achi. Huh? Asle kore. Asle kore.
For first hour, second hour.
Yes.
And with the observation that there is one injury before the charge sheet, that subsequently charge sheet was submitted, and the main assailant has been released on bail for 39 by this honorable court by the order dated 16/5/24 in BLAPL. I have annexed to this IA.
You grant parity, okay? I'll grant parity. Hold it. The following sentence.
Only one simple injury, say ground, and the informant has several antigen. That ground,
Anyway, parity will do.
on surrendering. On
No,
surrendering.
no. That will amount to recalling the entire order, which I will not do. The following sentence be added after. Following sentence be added after the end of paragraph 6. Further, the courts below shall also follow the principle of parity, since it is submitted that in the meantime, the principal accused has been released on bail. Yes.
Item 37. The date of
2 weeks for the time.
My lordship. Modification order dated 2/7/24, my lord.
2/7?
2/7/24, my lord.
Yes.
So lordship directed 2 months, my lord. Instead of 2 months, my lord, 2 weeks.
Yes.
Paragraph 6, last portion.
It is submitted that in paragraph 6.
5, my lord. 5 and 6.
Paragraph 5 and 6.
My lord.
Instead of 2 months, 2 weeks has been mentioned. Stop. Then State Council. Yes, what do you say? Man also submits that the court had granted interim bail for 2 months. So, in such view of the matter, the words 2 months be substituted in place of 2 weeks wherever they occur in the order dated 2/7/2022.
Okay.
Item 8. None appears. This matter 1 week after. Item 39. May I please
Sorry, 38. My lord, here one my lord, the one Delhi wager, admittedly Delhi wager is also confined, is languishing in jail custody since 24/7/2021. 3 years has already been elapsed. Trial has not yet been commenced. So, my lord, that is a huge quantity of gonja, 4 quintal 25 kg, carrying by a truck, and the petitioner having no nexus with that, only because the keeping that the words of the driver, he was also giving him a company and coming, and also now inside the jail. And he is also the entire family is a BPL card holder. Nothing, only 3 years has already been elapsed. The trial has not yet been commenced. So, considering
I will consider one thing.
Yes.
On perusal of the report of the learned district and session judge cum special judge both, it appears that the petitioner, after availing the interim bail, has defaulted in surrendering before the court, and accordingly NBWA has been issued against the
he is not availing any interim bail. He is now in jail. That is a Korno, another Korno, Parmeshwar Korno is.
You are Rajiv Malik.
My name is Rajiv Malik.
Achha. Look at the order dated BLAPL number 3898 of 2022. Rajiv Malik versus State of Odisha.
Rajiv Malik is now in custody.
This is the order passed by a court bench, Honorable Justice G. Gauri Shankar Satpathy.
Maybe some mistake, I think. Only that Parmeshwar Korno is also availing the.
So I will hold that this order has been passed by mistake.
No, but he is in custody.
So custody means say arrest. He custody to NBW is to NBW.
He has not granted any interim bail.
I don't know. This is the order.
Matter was heard by my lord. This matter, I think earlier occasion, 8189 of 21, my lord heard by the my lord.
True.
Since when he will granted the interim bail?
True.
He has not granted any interim bail.
Learned counsel for the petitioner submits that the petitioner has never been granted interim bail.
And the last occasion, sir, my lord also called for that.
Wait.
Regarding the trial.
Sir, please wait.
Yes.
Has not been granted interim bail. This court, however, finds that in BLAPL number 3898 of 2022, the coordinate bench of this court taking note of the fact that the petitioner had not surrendered to custody after availing interim bail, had disposed of the bail application accordingly. So, in view of the specific submission of learned counsel for the petitioner as referred above, list this matter before Honorable Sri Justice G. Satpathy, who had passed the order in the previous case, that is BL appeal number 3898 of 2022. Yes, registry to do the needful with permission of Honorable Chief Justice. Yes, let him deal with it.
Item 39.
My pleasure, Lordship. Lord. 2 years, 10 months.
Yes.
Lord, 2 years, 10 months. Custody since 29/9/2021. Twice he has availed interim bail. One was of 3 months, one was of 2 months, my lord.
Yes.
Out of 16 charge sheeted witness, my lord, only one witness has been examined for till now, my lord.
Consider.
Fortune order.
The court below is directed to submit a report regarding the status of the trial. Place this matter on
30th July.
30th July. This order will be communicated to the court below forthwith.
Obliged.
Item 40.
Please, please. Here, I am in custody in connection with a case on section 302 since 19/11/2021.
Yes.
The incident is alleged to have taken place on 18/11/2021. FIR is at page 10, my lords, of the brief. Lords, it was registered initially under sections 307, 323, 294, 324, 506, read with 34 IPs. The DC, one of the injured millards, succumbed on 13/12/2021 after being discharged from the hospital. And therefore the case has turned to 103.
Yes.
There is also no material to show millards that this petitioner was the assailant of that person who succumbed to his injuries. The informant statement I have annexed as annexure 3, millards.
Yes.
The informant has stated, Lords, you may see 10 lines from the top. ମୋ ଶାଶୁକୁ ପ୍ରଦୀପ ସେଠୀ ଓ ଶ୍ୱଶୁରକୁ ଗୋଲକ ସେଠୀ ଓ ତା ସାନ ପୁଅ ପ୍ରଭାତ ସେଠୀ ସୁରାଡ଼ି ଫାର୍ସା ଓ ବାଡ଼ିରେ ଆକ୍ରମଣ କରି ଆଣିଥିଲେ. The ଶାଶୁ କାଞ୍ଚନ is fell and hearty, millards. She has sustained a simple injury.
Has she been examined? This informant?
She has not been
No,
examined.
she has not been examined.
Rinarani Sethi. What about the others?
He has not been examined. There are so far, millards, about 5 witnesses have been examined. Out of them, there is an evidence of PW2, millards. He says omnivously that Golaka, his sons were assaulting Jaga alias Jagabandhu and his victim wife Kanchan Sethi. And if your lordship will look at the postmortem report also, the postmortem report also doesn't corroborate.
You have the postmortem report?
Postmortem report is there. PW4, your lordships.
PW4, yes.
PW4. Here specifically mentioned regarding the roles.
I saw that the accused, Golok Sethi, by
Yes.
Purati, gave blow to the head of Jaga.
And two
The two sons of Goloko, namely
Pradeep
Kapura,
Sethi is the present petition.
assaulting Jaga by means of ambush.
Bambushed. The head injury is attributed even by PW4.
Cause
to
of
Golok.
death is due to
Who is in custody?
cardiocerebral injury and its complications.
The other 2 injuries are on the legs.
And
this is a part of the same transaction.
It may be, my lord.
34 is there.
So far as the other co-accused, your lordship has granted bail.
Where is that? Where is that?
That is Nunia alias Pravat City. That
Prabhat City.
Prabhat, another son of that Golak city, my lord. Pradeep Sethi and Prabhat Sethi, they are the two sons.
I have granted bail to whom? This BLAPL 3073 of 2020. So who were the petitioners? I rejected the bail application of 1 and 2.
your lordship rejected the bail application of the father and this petition.
Okay. This was before the evidence.
Yes, yes. So before the
One axe was seized from Golak city, and from this present petitioner, one thick bamboo stick has been seized from him.
Yes. So who has been granted bail? Nanua.
Yeah.
Nanua Prabhat Sethi. What is his role?
Same melodies assault as to this petitioner. That he has assaulted Golok, but the head injury is that he has assaulted Jagabandhu, but the head injury is attributed to Golok.
That PW4 says, my lord.
PW4, okay.
Yes, my lord. Two sons, Golak alias Golak Sethi, namely Kabra alias Pradeep Sethi and Nunya alias Prabhat Sethi, started assaulting Jaga alias Jagabandhu Sethi by means of bamboo stick.
But the previous statement is that I saw the accused Golok Sethi by Kuradi gave blow to the head of Jaga.
Yes.
A stitch wound postmortem under single stitch.
Pass on the postmortem report. Oh, 34 will definitely come into the picture.
My lords, 34 will always come, my lords. Bail is considered. Take that into consideration. The injuries I am reading out. Stitch wound of 20 cm length with over anterior aspect of right inner thigh. Another stitch over the right knee. Then the second injury is stitch wound of 4 centimeters length with 4 numbers of stitches C-shaped on right upper thigh. And the third injury is the craniotomy surgical wound of 25 centimeters with 22 numbers of stitches over the right fronto-parieto-temporo-occipital area, partially healed. That is the injury to which specifically PW4 attributes to Golak.
Yeah, what is he doesn't say anything about he simply says the aforementioned, the mentioned external injuries and its internal findings are antemortem in nature and could have been due to hard object.
Yes.
Do you have a copy of the postmortem report?
Yes, I have read it.
Can you pass it on? Yes. Death is due to craniocerebral injuries and its complications. However, police has been advised to produce the treatment record for final opinion. Time says nail treatment.
6 weeks after the incident.
Occurrence 1811 and died on 1312.
All right. The petitioner is in custody since?
He is in custody since 1911-2020.
1911-2024. 21. In connection with such and such case. The prosecution case is that the petitioner being the petitioner accompanied his father
and brother,
all of whom were armed with deadly weapons, and brutally assaulted the deceased, causing his death. Stop. Sri Devasis Panda, Learned Counsel for the petitioner, referring to the statement of the informant recorded under section 161 of CRPC would submit that the allegation of assault by means of axe is
Attributable to the co-accused.
Duplo prosecutity or probacity is attributed to co-accused Golok Sethi. And insofar as the petitioner and his brother are concerned, they are alleged to have assaulted the mother-in-law of the informant. Stop. The copies of depositions of the witnesses examined so far are on record and have been referred to by Sri Ponda. It is submitted on such basis that there is clear evidence that accused Golok Sethi gave a blow on the head of the deceased by means of an axe. He further submits that death is due to the blow on the head as evident from the post-mortem report. Learned State Counsel has opposed the prayer for bail by submitting that the petitioners, there being clear evidence that the petitioners also participated in the joint assault, though by means of bamboo sticks, are jointly and severally liable for the death of the deceased. Para. I have considered the rival submissions and have also gone through the case record, including the post-mortem report and the statement of the informant and other witnesses. It prima facie appears that the blow by axe was dealt by co-accused Goloko on the head of the deceased. So, as per the post-mortem report, death was caused because of such blow on the head. Insofar as the petitioner is concerned, it is alleged that he assaulted the deceased along with his brother by means of a bamboo stick, causing injuries on his lower limbs. In taking into consideration all the above facts, a lenient view can be taken. The bail application is therefore allowed. Each day appearance without representation. Yes.
Okay. Item 41.
As per my lord's direction, I have to.
Please file it.
With a prayer, my lord, I will file my written submission.
Yes.
But I have not argued the case. That is only if I
argued that day?
No, that. Anyhow, my lord, so when my.
No. I am sorry, sir. If you can make such a statement, I am sorry. Release this matter tomorrow. Kalita matter rakhantu. Se matter ta kali rakhantu. CORAM to inform kar.
Tomorrow is the holiday.
Tomorrow, day after tomorrow.
The petitioner is in custody since 27/8/23, my lord, being implicated in a case under section 458, 395 IPC and 25/27 of Arms Act, my lord. I have filed an IA for interim bail, my lord.
On what ground?
Wife of the petitioner is suffering from neurological disease, my lord. She is a chronic patient as it reveals. Also, sir.
Take instruction.
Bunch of medical certificates are there. She is suffering.
It's the period 21, 22, 23. All are there.
24 रो भी अच्छी देखो.
24
Refer करते हैं MRI and neurological.
I refer to list this matter next week. Learned State Counsel shall obtain instructions with regard to the medical documents and close to the IA. Yes.
Item 42.
May I please, Your Lordship? The second round journey law. Earlier occasion, in the last occasion, Your Lordship called for the CD. Offense under section 302 and custody since law 26/1/2020.
Earlier rejected?
No. Withdraw voluntary withdrawal.
Yes. Voluntary withdrawal or
course of hearing?
Being suggested by the court?
File was with me. Last occasion also file was with me.
I
Yes.
was not having with the record.
On लिखिला you received information one female dead body aged over 40 years has been lying on the road. Some unknown copies of container through the dead body. Yes.
Unknown
Yeah.
attire, my lord.
Hmm.
No eyewitness, only circumstantial evidence. And
What are the circumstances?
last scene theory is there. And the mobile phone of the deceased has been seized from the present petitioner. He has hid in ଗୋଟେ ପଥର ତଳେ ଲୁଚେଇକି ରଖିଥିଲା. And cause of death, my lord.
Not at the instance of the accused, my lord, that was
Has cut the throat of the deceased with a thermocol cutter.
Why? What is the motive?
Motive, my lord, there is suspicion that both are living, my lord, in one house, my lord. And there was extramarital affairs with other men, my lord. For which, my lord, they are suspecting that this petitioner is committed.
What is the material? Only 27.
Only 27 and last scene theory.
Who's the last scene theory?
Last scene theory, my lord, one Thantapu Reddy Suresh is the villager.
What does he say?
My lord, ମୁଁ ତାଙ୍କ ଗାଁରେ ରହୁଛି ପି ରାମକୃଷ୍ଣ ମଧ୍ୟ ପି ରମଣ୍ଣାକୁ ମଧ୍ୟ ଜାଣିଛି ସେ ମୃତ ଓରାଲକ୍ଷ୍ମୀ ଘରକୁ ମଝିରେ ମଝିରେ ଆସନ୍ତି ଓ ତା ସହିତ କଥାବାର୍ତ୍ତା ହୁଅନ୍ତି ଓରାଲକ୍ଷ୍ମୀଙ୍କ ସ୍ୱାମୀ ଏ ଗୋପାଳ କୃଷ୍ଣ ଦୁର୍ଗା ପ୍ରସାଦ ଆଉ ଗୋଟିଏ ସ୍ତ୍ରୀ ସହିତ ବିଜୟୱାଡାରେ ରୁହନ୍ତି ଓ ମଝିରେ ମଝିରେ ନିଜ ଘର କୁଆଁପଲ୍ଲୀକୁ ଆସନ୍ତି ଯେହେତୁ ସ୍ୱାମୀ ଘରେ ରହୁନଥିଲେ ତେଣୁ ଆକୁରାତି ଓରାଲକ୍ଷ୍ମୀ ପି ରମଣ୍ଣା ସହିତ ସମ୍ପର୍କରେ ଥିଲେ ଗତ ତା 20/1/2023 ସକାଳ ପ୍ରାୟ 11 ଘଟିକା ସମୟରେ ମୁଁ ଆମ ଗାଁରେ ଥିଲି ସେହି ସମୟରେ ଦେଖିଲି ଯେ ପି ରମଣ୍ଣା ଗୋଟିଏ ବଜାଜ ପଲ୍ସର ମୋଟରସାଇକେଲରେ ଆକୁରାତି ଓରାଲକ୍ଷ୍ମୀ କୁ ବସାଇ ନେଇଥିଲେ
କେତେବେଳେ ଦେଖିଲେ କୋଉ ତାରିଖ କେତେବେଳେ ଦେଖିଲେ
ଗତ 20/1/2023
20/1/2023 କେତେ ଟାଇମ କେତେ
11 ଘଟିକା
ଦିନ 11ଟା when was she found?
She was found, my lord.
She was found on 21st January 2020.
Next day.
And his son also said the same thing. He has seen that the present petitioner motorcycle basegi.
No, son was not there. They are residing at Andhra Pradesh.
Son of the deceased.
On hearsay, my lord, they disclosed that this person was.
No, he called extremely well.
Only.
All right. The petitioner is in custody since
26th January 2000.
Thermocol cutter has been seized from the spot, my lord. And one mobile phone of the deceased has also been seized, which he has concealed.
26/1/2023 in connection with circumstances. As per the FIR, a dead body, the dead body of an unknown female was found lying near the road. On commencement of investigation, upon commencement of investigation, the complicity of the petitioner came to light and he was taken to custody. Learned counsel for the petitioner submits that there is no direct or indirect evidence to show the complicity of the petitioner in the alleged occurrence, and that he has been implicated only on suspicion. Learned State Counsel has opposed the prayer for bail by submitting that there is clear evidence to show the petitioner's involvement in the form of the statements of some witnesses who had last seen him with the deceased on a motorcycle. Further, the petitioner also gave recovery of the mobile phone of the deceased, which he had kept concealed under a rock, under a stone.
Yes.
Para. After considering the submissions and the materials on record, this court finds that the time gap between the so-called last seen, the time gap between the gap between the time when the witness saw the petitioner and the deceased together and the recovery of the dead body appears to be quite long. Appears to be long enough to not rule out the possibility of someone else committing the crime. This is being said in view of the fact that there is no other admissible evidence to show the presence of the petitioner at the spot. The so-called recovery of the mobile phone of the deceased at the petitioner's instance cannot come in the absence of any other evidence conclusively show the involvement of the petitioner. In such view of the matter, I am inclined to allow the prayer for bail. Let the petitioner be released. He shall not leave the territorial jurisdiction of the court without obtaining leave. Next, he shall furnish his contact address and telephone number to the IO as well as the court before being released. Next, he shall appear before the court on each date of posting of the case without seeking representation.
Item 43.
Your Lordship, in item 43, Senior Counsel Mr. D. Naik has been engaged in this matter, Your Lordship, but due to some personal difficulties, unable to appear today before Your Lordship. May I pray that the matter be taken up day after tomorrow, Your Lordship?
Day after tomorrow. All right, please, this matter day after tomorrow is prayed for.
I'm much obliged, Your Lordship.
Item 44.
Please, Your Lordship. First noting since 2/7/2024. Offences under section 20A(1) of NDPS Act. Allegation that cultivation of 20,000
hemp plants. All right, same order.
पूरा गांव सारा फाइल
All right, same order.
Item 45.
Please, Your Lordship, item number 45. My
Yes.
cleaner is currently out of station. May I please,
When do you want?
yes,
When do you want?
day after tomorrow?
How
A short adjournment, Your Lordship.
this matter day after tomorrow is prayed for.
Your Lordship, interim order to continue.
Interim order to continue.
Item 46. 46.
May I please, madam? In similar situation, one co-accused already released on bail, madam. Omnibus allegation against 10 to 12 persons cutting can do this, madam.
Yes, same order?
My lord.
Same order.
Unknown persons, but
Yes, my lord. Yes.
my lord.
Item 47.
47. May I please? In this case, I am for the right, my lord. Paper to transfer my CMC case number 16 of 2022 pending before the London Judge Family Court. That should have to London additional district judge Panjanagar as is residing as Buda and another cause my lord. Two of his our child, my lord, and sir.
CMC ମାନେ କଣ maintenance? Maintenance.
Maintenance. These ଛୁଆ ମୋର ପଢୁଛନ୍ତି
You are appearing, Mr. Out.
Lord.
Mediation court na?
Multiplicity of case, Lord. So many cases have been filed in the area of Jharsuguda, Lord. In the district of Jharsuguda. Lord, she has also filed DRP civil 47 or 2024.
So let it come together.
Yeah. Let them appear for an
Conciliation though? No, let that come. We'll pass an order. List this matter next week along with the TRP.
TRP again. C 47 of 2024.
TRP C 47 of 2024.
File ହେଇଛି ଆପଣ ଫାଇଲ କରୁଛନ୍ତି
yes ସେଟା ଆସो ଏକାଠି ଅର୍ଡରଟା ପାସ୍ କରିବ yes ଦେଖ
Item 48.
This is regarding correction of the name of the petitioner, my lords.
The order be corrected accordingly. Huh?
May I pray, my lord, since I have already obtained the certified copy of your
The certified copy be submitted for correction.
So item number 29.
ये गोटी के पास और चला yes
Can you see the status report?
let me see the postal tracking report.
My lord.
That notice has been served on the opposite party. There is however no appearance. Service each koduno te beji 4-7 reach apne time daba. Land counsel for the petitioner is present. In order to grant one more opportunity to the opposite party to appear, let's this matter next week. Kadam, Dara. ऑर्डर सोडा की तरफ नहीं गया पैटर्न सही नहीं ऑर्डर से पेज में जाई छी पूजा नहीं ऑर्डर से नहीं गया ऑर्डर सोडा साथ देगी तब पुणी ऑर्डर फोटो जो साथ से न करो
Weekly list item number 12.
Item 12, if I may please your lordship.
Substitution.
Substitution has been filed. The substitution of the sole appellant, your lordship. The IA number 968 is the petition for substitution, your lordship.
When did he die? Is there a delay?
24/7/2018. Yes, your lordship.
When was the petition filed?
Petition has been filed.
2022.
Yes, your lordship. 23/9/2000.
What is the reason for delay?
Your lordship, the sole petition, sole appellant was the person who was in contact and was aware about the case. The LRs, they were not aware about the case and they were taking upon.
It I go to 967 of condonation of delay. This is an application for condonation of delay in filing of the petition for substitution of the sole appellant. It is stated that the appellant died on
24/7/2018.
24/7/2018. Stop. This further, it is submitted by land counsel for the appellant for the petitioner that the deceased appellant was looking after the case and was in contact with the lawyer. However, the LRs, being ignorant, could not approach the lawyer to take necessary steps for substitution after his death. Further, because of the situation arising out of the COVID-19 pandemic, prompt steps could not be taken. Considering the submissions and the grounds cited, I am inclined to take a lenient view. The delay in filing of the substitution petition is hereby controlled. 968 or 966 na?
Again.
The sole appellant died on 24/7/2018, leaving behind his widow, 5 sons and 3 daughters, as described in the schedule.
Again.
As described in the schedule. Where's the schedule?
Page number 3, your lordship. It begins page number 3.
As described in the schedule. Stop. It is submitted that the right to sue survives in respect of the legal errors. In such view of the matter, therefore, setting aside abatement সেটা allow করবে substituted লিখবে the LRs of the deceased appellant as mentioned in the schedule be added as appellant numbers 1A to 1I. The LRs have also filed wakalatnama.
Yes, sir.
Which is on record. Stop. Consolidated cost title.
I have it ready, Your Lordship.
Ready? Is also filed in court today. The same be incorporated. So this shall come for admission now.
Yes, Your Lordship.
Any other defect?
No, Your Lordship. It may be called upon.
No, deficit code is there.
The noting shows that the same has been paid, Your Lordship.
Okay. Okay. List this matter for admission.
I have a humble prayer. As the execution case is proceeding before the learned executing court, the matter may be, date may be fixed for the admission.
List this matter next week?
Yes, sir.
For admission? Yes. Oh. 29? List this matter in the week commencing 29 July.
Much obliged.
Item number 14.
This matter, my lord, the notice had gone. So for the 1 to 4, the tracking report is there.
Okay, let me see that. Item delivered. Notice on respondent number 1 to 4 appears to have been delivered as per the postal tracking report. There is, however, no appearance. Notice on Tago
5 is reported.
Respondent number 5 has returned with the report deceased. 2 weeks time is allowed to the counsel for the appellant to take steps for substitution. Respondent number 6 ta 6 ta bhi jaichi 1 to 4 and 6 par
1 to 4 and 6.
Yes. 2 weeks time to take steps for limitation. Yes.
Obliged.
List this matter 2 weeks for 20th August. Was it a week commencing? Yes.
Item number 15.
My please, Your Lordships.
As per the noting, IA number 303 has been filed for deletion of the name of respondent number 8.
You want to delete respondent number 8?
Yes, my lord. Because respondent number 6, 7, 9, and 10 are legal errors are on record.
But notice has not been returned from them.
Lord's notice wasn't issued to respondent number.
No, there are 3-4 notices. Respondent number 26 has to be substituted.
26 has to be substituted.
Then respondent number 10 has to be substituted.
Yes, my lord.
8 has to be substituted.
8 has to be. 8's legal errors are on record, my lords, as prayed in the.
So why did you file a petition then?
For deletion of.
Deletion. Okay. Okay. IA 303 of 2024. This is an application for deletion of respondent number 8, who died on 21/9/2017. It is stated that his legal errors, her legal errors, are already on record as respondent numbers 6, 7, 9, and 10. As such, no steps for substitution are required to be taken. Considering the above facts, IA is allowed. Respondent number 8, Subhadramani Mahanti, be deleted at the risk of the appellant. Yes. Tapre?
IA number 304 of 24.
Is it in time?
No, my lord. My lords, it has the respondent number 10 died during the appellate stage. and there was no substitution taken place during the first appeal. We found it out later in the middle of the second appeal when we filed it immediately.
So you have to file petition for condonation of delay and setting aside abatement.
Millards, the respondents for the appellants in the trial court, in the trial.
So what? You want to substitute them, you have to satisfy the court. Isn't it? Let it lie over.
Millards,
Let it lie.
we'll obtain instruction and the exact date of
Yes, yes.
respondent and appeal.
Then 305 is respondent number 26.
26 minutes.
Where's the delay petition?
Millards,
307.
307 minutes.
307 of 2024 IA. This is an application for substitution of respondent number 26, Santilata Das, who is said to have died on 25/7/2021. It is stated that the sole appellant, being aged about 71 years and ailing, could not visit his counsel at Cuttack to impart necessary instructions. In the process, there was delay. There has been delay. Considering the submissions and the grounds on which the reasons for which the delay has occasioned, I am inclined to take a lenient view. The IA is allowed. Delay in filing of the petition for substitution is controlled. The IA 305 or 306 को इकट्ठे न हो. This is an application for substitution of respondent number 26, Santilata Das, who is said to have died on 25/7/2021, leaving behind her husband, two sons and two daughters as legal heirs, the particulars of whom have been described under the schedule to the IA. It is submitted that the right to sue survives against the legal heirs of the deceased respondent, and therefore they need to be substituted in her place. Considering the submissions, allowed करते तो कौन? Abatement, order of abatement set aside. Substitution allowed. Consolidated cost to be filed within a week. Thereafter, notice will go to them. No, somebody is appearing.
No, my lords. Only notice the contesting respondents for respondent number 1 to 8. Only notice was prior when the appeal was admitted. Only notice was issued to 1 to 8. Respondent number 1 to 8. So, performer respondents.
All right. It is submitted that the notice of the appeal was not issued. Was issued only to respondent numbers 1 to 8 who are contesting. Stop. The other respondents are pro forma respondents, are pro forma parties, and therefore no notice need be issued to the substituted parties, to the newly added parties. Huh? List this matter in the week commencing 27th August.
Obligation.
Item number 16.
Two interim applications pending. One for seeking relief for dispense with the filing of certified copy of the trial court judgment for the timing. I have applied. I will file within 15 days. IA number 777 of
IA number 777 of 2024. 2 weeks time is allowed to the petitioner to file the certified copy. That's all.
Yeah, another interim application for condonation of delay.
You file the certified copy.
Thereafter. Okay.
File करो. Delay टा सही to calculate हो.
Appellate court judgment and calculation of calculation is 5 years 11 months. Trial court judgment क्या है मतलब?
आसू. देखो.
Item 17.
Item 17, my lord, we have already taken step for limitation while filing an IA, my lord. It has not come on record. IA number 811 of 24.
All right, list this matter in the next week. List this matter in the week commencing 29 July along with IA number
811 of 2024.
811 of 2024. Yes.
Item number 18. 25 is in 11.
Notice book.
It's my government issue.
Government. Okay. Yes.
25 days delay.
25 days delay will continue. IA 490 of 2023. This is an application for delay of 25 days in filing the appeal. So it is stated that, where have you explained that because of prolonged illness of the appellant, number 4, who was looking after the case on behalf of the other appellants, the appeal could not be preferred earlier. Stop. Learned AGA, appearing for the state respondents, has no serious objection to the delay being controlled. In such view of the matter, delay in filing of the appeal is controlled. Let us take it up for admission then.
Yes.
The matter is taken up for admission on consent of the parties. Yes, what is the matter? Yes, Mr. Marty, what?
Not ready. Order day.
Ready?
No.
It's are they
For orders, it was listed for that.
ये orders कौन ये कौन है जहाँ से सोरी साथ तो दवा orders.
I would say.
There's this matter for admission in the week commencing 29 July.
Well,
29 July.
no, August. August.
Oh,
I will remain absent.
5th August.
Item number 20.
Your Lordship, White order dated 2/5/2024. The matter was referred for mediation, Your Lordship. The same has failed.
I think you are referring to some other matter. This is of Mr. Ashok Sorangi. Liaquat Ali Khan. Appellant is Liaquat Ali Khan.
Item 20 is Soilawala Vishwa.
भूलटा मार दीजिए. Item 19, oh, 19 Arjun ji. Okay. So what has happened here? He has gone to mediation.
Yes, Your Lordship. Mediation has failed.
All right. Report of the mediator indicates that mediation between the parties was unsuccessful. Now everything is ready.
Yes, yes.
It has been admitted.
About to, yes, yes.
It has been admitted.
You take it up for hearing there 2023 matter asu.
Not other. It's only a money suit, recovery of money. Now interim order has been passed. Kindly have a glance at the interim order. That is passed on
Interim order has also been passed on the same date.
2/5/2024.
Execution has been stayed.
No, further proceedings were stayed. Further proceedings in the execution case were stayed. We'll take it up for final disposal. When can you be ready?
Next week?
Next week to have money.
Any date, you know. Karana tonka bhi kisi deposit karna hai. It is to be deposited because it's simply money.
Both parties agree that the matter can be finally disposed of. So we don't need the LCR.
LCR was called for in the last occasion, on the date when it was admitted. But the
Photocopy has been received.
I received.
No, it was called for. Received is
noting the kuch asini boli.
Asin na? Acha, how?
It's from Bhubaneswar only.
Bhubaneswar will demand the court, but will first week of August go to Karo.
Commencing 5th August.
List this matter in the week commencing 5th August. The court below be remanded to send the LCR as directed positively before the next date. This order be communicated to the court below forthwith.
Interim order may be continued.
Interim order to continue.
So interim order ta say hochi the IA 1529 te kindly dekhiye. The second part of the order, paragraph 2.
Yes.
Further status quo with regard to the suit property be also be maintained till the next date.
It is
immovable property kisi nahi.
No, sir, bhule badar ho jayegi.
Seta, in fact, the property of the this appellant, that's a residential property, and that he.
But in any case, this is a money suit. This has got nothing to do with the property.
Nice.
So that we will delete it.
The Your Lordship said na so ekathare to sundar sir.
Okay.
Anyways,
all right.
Seta.
Correct. Admission to Kujan Jaitna. Not so bad.
We commencing 5th August.
Huh? 24 or more. ठीक?
तीन का दिला
Hmm?
तीन का खाली दूसरा दिला
24 আমরা admission की तरह Oh, it is Sardo. Well, it will take it up, take up the Passover matter and then.
সেটা আবার পরে পড়ি বলি
কর দিন
সে 3 নম্বরটা
কর দিন It has been heard substantially.
Sir,
You wanted to, I just wanted you to go through my judgment and to.
Sir, I have gone through your lordship judgment. I have gone through not only your lordship judgment, I have gone through the similar judgments passed by this honorable coordinate benches of this honorable court. I have got one more judgment also. Right, madam? Your lordship judgment is dealing with son of that lady, widow, through second husband. Your lordship judgment deals with that point. I have carefully gone through. Your lordship has referred to Bombay High Court judgment. Correct, madam? My lord, I have also gone through a judgment delivered by my lord Justice A.K. Rathore as his lordship was there on this very point. On this very point. I have also gone through, there are several Supreme Court judgments on. My lord, not with highest regards, not with great respect to the judgment passed by my lords. I have an opinion. It's for me. I may be wrong. It's a proposition of law only. It's not nothing else. I don't mind who is getting the property, who is not getting the property. I don't mind. I am only on a proposition of law. Whether section 15(2)(b), where 15(1)(a) to (e) are excluded now under operation of law. And that provision which starts from a non-obstante clause, notwithstanding, means 1(a) to (e) is excluded. And the very word, if your lordship sees, whether any of those judgments, including your lordship judgment, with great respect, my lord, has dealt with that proposition of law or not. If it not deals with that proposition, I may argue that that is for including. With great respect to my lord, sir.
Yes, you can validly argue that point.
But I have carefully read it with great respect to my learned senior also yesterday. But I also need to have little more research on this because it's a very important question of law. If lordship sees that for the
Mr. Author, I have a very open mind.
I know.
I'll tell you one thing. I have got every right to pass a wrong order.
I know, my lord. I know your lord.
If I have passed a wrong order, no, if I passed a wrong order, it has to be corrected.
I never say wrong.
No, it could be wrong.
Provision should have been addressed to my lords in a given fact and situation.
So you can address the court on that issue.
Yes.
Had that point been taken into consideration, what would have been the result?
What will be the consequence? But I also, it's a very important question of law. It will have a deep-rooted effect.
Yes, yes.
So I'll also require, I'll have to do some more research on this. Yesterday I have worked. Today morning also I have worked. I have collected 5 to 6 judgments on the point, including the coordinate bench of the Honorable Court, Honorable Supreme Court. Apart from 2002 other judgments also I have collected. I'll give all those judgments to my lords. Let there be a proper question of law be set.
What do you say, sir? You just want to one at a time, that's all.
No, proposition of law can be advanced, there is no difficulty. But facts and circumstances of the cases has to be taken.
Yes, sir.
Let him also examine.
Yes,
definitely.
Here, Muller, as I submitted, the defendant number 1 is the adopted son. That was held, no, is not an adopted son. That was confirmed. No second appeal is filed. He is the only contesting respondent, Miller.
No, but I would like to pause you for a moment here, because yesterday also he submitted that he is not only appealing for that, but he is also appealing for the other respondents.
Yes.
Technically.
No, another Miller, second point, Miller. Now, Miller, I have made defendant number 2 and 3 as parties. And Miller, the defendant number 2, 3 were set ex parte. They have not filed written statement. They have not given any pleading available on this. Miller, in view of the judgment of the lower appellate court, where Miller, not only that adopted is not accepted, but also they have said the present plaintiff is the successor of the widow, that is the mother. Sumitra Miller. That is also not challenged.
You examine the effect of this.
No, I am saying that what is the.
Sir, I'll address with great respect to my learned senior Mr. Rao.
You address
conscious of those situations. I'll address.
No, that's why I'm pointing out.
I'll definitely.
Whether in these circumstances, Miller, your lordship decision, and this Justice Raghuveer Das also has given a judgment, Miller, and on the basis of 2002 Supreme Court, which we are relying both the parties, that is very clear. That the point which my learned friend is arguing, that was made clear. Miller, that is a case where Miller, the mother, this is when the before partition of the India, Miller, that was portion of the area, Miller, in the India. Thereafter, in partition, it has come to Pakistan. One care, Miller, that is
87 Supreme Court.
No, 2002 Supreme Court.
2002 is.
That is Bhagatram versus.
Sir, we'll take it up on that day. Let us consider all the judgments seriatim on that day. So you also cite.
This is not the case. This is not the case.
Yeah, we can say if it is not the case, then we can distinguish it on facts.
Yes,
we will do that.
Yes, yes.
But
let me not.
In appropriate cases, Miller, if your lordship accepts my submission, that's not necessary to consider all the cases in the facts and circumstances.
Let us see that.
That is the point, Miller.
Since it's a proposition of law, and I have also pronounced a judgment, there might be some doubt with regard to the correctness of my judgment also. So I would definitely like to go through
your lordship.
I'll give both in my favor, against me.
Yes.
Against me, my favor, everything I'll give.
The Bombay High Court is against you.
Bombay High
Which
Court
I have
is
followed,
against me.
which I have
There are
followed.
some other judgments against me, but only thing I am required to explain is that exclusion in the notwithstanding clause, whether has been considered in those judgments.
Yes, Miller. 2002 it has been considered.
There is one point which I would like you also, the senior counsel, Mr. Rao, that the children born to a widow from her second marriage,
Yes.
they are also her natural born son, children.
ସେଇଠି ହେଇଛି point ଟା
So-
ମୁଁ ଖାଲି କହିବି ଆପଣ ସେ 15 ଟା ଗୋଟେ ଦେଖନ୍ତୁ
ନା ସେଟା ଆପଣଙ୍କ exclusion ଅଛି।
Before going to the
ଆପଣ ଦେଖନ୍ତୁ 15 ରେ କହିଲା a lady dying intestate, a female dying intestate in absence of any son and daughter, right? The heirs of the husband will succeed to the interest of the female, right? And to the exclusion of 15(1)(a) to E means children born to second husband. To the exclusion. So why the legislature in its wisdom consciously excluded 1(a) to E, who are the children born through second husband? If they are excluded from operation by a non-obstante clause, which will have an overriding effect over one. Non-obstante clause is overriding one. Then children who are excluded, whether can again inherit. That, what is the legislative intention? Then the intention of the bill has to be shown to my lords, which I am collecting.
Yes. Find out the statement of objection.
Yes, I am collecting. I am collecting.
All right. Heard further arguments in part. Let's this matter in the week commencing 29th July.
29th July, Miller, I will be absent.
No, the entire week.
Miller?
Week commencing 29th July.
Yes, I am going.
You'll be absent.
Check up.
When can you come back? When will you be coming
Second week of August.
Second week of August.
Second or
5th of
third.
August.
Week commencing 12th of August.
Or Miller, next week, anything, Miller, even 3-4 days.
Bill collect.
I am Miller available up to 26th.
No, next
Which
week.
is the Miller?
No, I'll tell you.
Miller, my land friend allows, I will place the facts. Thereafter, Miller, this is, according to me, what my land friend is making submission that has been answered in 2002 Supreme Court.
Yes, sir, all right, sir, we will see that.
So let
thing
it
is
come,
that
Miller,
next week,
before 24th.
we will be having some election matters. They have been assigned to this court, so that will consume some time.
5th of August. That will.
26th, 25th, 26th, 26th, 27th.
I am also have my own engagement.
We can take it up. We can take it up on 26th.
Sir, 26th ରେ ମୁଁ ବାହାରେ
So 26th तो छुट्टी है हमारा.
ମୋର assignment ଛୁଟି ତ ଦେଖା ଯାଉନି ମୋର
High
ବାହାରେ
Court Foundation Day छुट्टी नहीं.
Or outside engagement also
नहीं
26 है।
तो ठीक है सुबिल
Sir, कौन विचार दिन ना कौन?
My problem, if I will be out of Cuttack Miller.
No, that's all right. I will take it up. कब पूछना है? 5th August for it. 12th August. We commencing 12th August.
Well,
Yes.
So great.
Yes. Take up. Admission वकील जांच की तरह रखो। ये बाबा ये कौन दे रहा है? Yes.
Miller, factually, I am giving a note, only facts. Miller.
Please, please.
Let I will also share a copy.
I'll give you a copy also.
Not necessary at all, Miller.
No, we'll see that, sir. We'll see
If
that.
the appropriate cases, Miller, that can be dealt with.
Yes. Well, is anybody there in item one?
Decisions I have not given, Miller. Two decisions thereafter, after your lordship decision, Justice Raghuveer Das, that is reported in 2014. CLT,
have seen it.
180,
I've
that's
seen it,
CLT
sir.
Miller. That is they also dealt with.
All right.
2000 Supreme Court is clearly dealt with this point, Miller. That Miller judgment copy.
All right, sir. I will see it on that day. I will see it on that. Yes.
Lordship, my learned senior SP Mishra is on his legs, your lordship.
Whenever the matter is called, you are making the submission.
Last time I argued, your lordship,
So argue, complete the argument.
Uh,
Whenever the matter is called out, you are saying that my senior is on his legs.
few of
So
the,
the court cannot be paralyzed like this, sir.
with your permission,
I take it out of the list then.
with your permission,
You have argued that day.
your lordship, I argued.
Just a matter of my senior is on his legs.
With your permission, your lordship, I may start, your lordship.
Sir, this court respects seniors. That does not mean that this court will run according to the whims and fancies of
I'm
seniors.
sorry, your lordship, I'm sorry, I may start.
Please argue the matter.
Your lordship. If your lordship may come to page 2 of first appellate court judgment, your lordship, genealogy is given, your lordship.
Page 2 of the first appellate court judgment.
Appellate court judgment.
All right.
One Mano was the common ancestor of the parties, your lordship, who had two sons, Deborah and Dumka.
Yes.
Now Deborah had three sons, Guru.
Who is opposing you? Who's the other side?
Other side.
Nobody is there.
No.
Conclude. Complete.
And so Deborah had two sons, one daughter, Gura, Bhuja, and Sunya. Sunya is the daughter, your lordship.
Yes.
Now present plaintiff is the son of Gora. She is the daughter of Gora.
Salma.
Gauri, your lordship. Salma is the wife of
Acha. Gauri.
your
Yes.
lordship. And the defendants are the branch belonging to Dumka.
Gauri is dead. But D कौन election थी? She election जुटा D.
Daughter, your lordship.
Okay, daughter.
Your
Okay.
lordship.
Then
The defendant, they belongs to the branch of Dumka, your lordship,
Hmm.
who had two sons, Dulla and Maka. Dulla had two sons, Gajendra and Jabba, who are defendant number 2 and defendant number 3, your lordship. Now here, the plaintiff has filed the suit for declaration of right, title and interest and confirmation of possession, and in the alternative for recovery of possession and permanent injunction in respect of Schedule A property. Schedule A property is the ancestral property of the common ancestor, which devolved through common ancestor Mana, your lordship. Now it is the case of the plaintiff that there was an partition, oral partition in the year 1970. And pursuant to that partition, suit property have been divided between the branch of Gora and the branch of Dumka, your lordship. So I'm relying, your lordship. In the next page, your lordship, where they have admitted that there was prior partition between Gora and Dulla.
I am reading next page था सुनी कौन लिखा है कोई जगह जो गारमा रही
Your lordship.
मो भौनी कौन है
एकमात्र कन्या गुरु देई उत्तराधिकारिणी अछंती तापर माय लॉर्डशिप
हाँ
देवर माझींकर एक कन्या सुनियर देई उत्तराधिकारिणी अछंती गोस पितांकर एक कन्या माक देई उत्तराधिकारिणी अछंती आजकू प्राय 5 वर्ष हेला माक देई सुनिया देई गुरी देई ओ आंभे दातांक मध्यरे गोस पितांक नामित
मैंने जेजापा
आज्ञा पंचायत रे आपोस रे बंटन करी देई जहार बाबद जमी को अध्यावधि निर्विरोध भोग दखल करी आसु अछु.
So this is the only proof of your prior partition.
Your lordship, that they have admitted in the recital of the sale deed that there was prior partition between the Gora and Dulla. And on the basis, since the recitals are clear, your lordship, so therefore they cannot dispute this the content of the recital, your lordship.
So this is by Dulla, Dulla Maji.
Dulla Maji.
Dulla Maji, defendant number?
Defendant number 1, your lordship.
Defendant number 1. All right. Okay, then.
Now,
so how did the trial court or the appellate court deal with this?
The trial court as well as first appellate court, they held that your lordship may come to page number 12, your lordship.
Yes.
Page number 12, your lordship, para number 12, last 5 line, your lordship.
Of which judgment you are reading?
Lower court, your trial court, your lordship. I'm sorry. It was mentioned, it starts from, it was mentioned. It is.
It starts with the plaintiff has tried to take advantage.
Your lordship, that paragraph starts from that the defendant number had admitted in the previous sale deed, Exhibit 1 in 1975, that there was partition between Dulla and Gaurav. Now, this was denied by defendant number 1, and it is contended by this right that since defendant number 1 is a rustic Adivasi, he had no knowledge what was scribed in the sale deed by the deed writer.
Se sign korchen na tipo dichen.
Se sign korchen. Your lordship, I may also read that.
ठीक है.
Your lordship. The plaintiff has not tried to establish the content of the impugned sale deed Exhibit 1 by examining the scribe or any of the attesting witness. On perusal of the contents of the deed, Exhibit 1, it was mentioned as after death of Gaurav, his daughter Gauri and after the death of Devra Maji, his daughter Sunia is the heir, and their grandfather has a daughter Manka. And since 5 years, there has been partition between Manka Dei, Sunia, Gauri, and the vendor Dulla over the property of their grandfather by way of amicable partition in the Panchayat. So, as per the above content of the sale deed, it was mentioned that there was prior partition between Gaura and Dulla, but in the absence of proper proof of the contents of Exhibit 1, the plaintiff cannot take the advantage from it that there was prior partition between her father and Dulla in view of the above content. So, Your Lordship, my respectful submission in this respect, Your Lordship, they never denied the sale deed, Your Lordship. They have admitted that this sale deed was executed by the Dulla, Your Lordship. Only plea they are taking is that since it was not in their knowledge, the recital of the partition, this sale deed, it was not in the knowledge of the CORAM. Now, Your Lordship, when the recitals are clear and they have been read over and explained to him, and after understanding the content thereof, if somebody is signing it, then Your Lordship, it becomes binding on that person about that recital, Your Lordship. So, therefore, in my humble submission, Your Lordship, both the court below, they have taken the same plea. So, it is not sustainable in the eye of law, Your Lordship. Now, if Your Lordship, I may take to first appellate court in respect of the same finding, Your Lordship.
Reiterate question.
Your Lordship.
Then, so oral evidence according to you should not have been admitted in this regard.
Your Lordship.
Section 92.
Your Lordship. I am grateful, Your Lordship.
Then,
Your Lordship, first appellate court has dismissed this appeal.
This is the only ground or some other ground is there?
This is the only, on merit, this is the ground. And on technical ground, first appellate court dismissed the suit on the ground that this first appeal, it was not accompanied with the judgment of the trial court, Your Lordship, that I was arguing on the previous date, Your Lordship. So, since it was not in compliance of Order 41, Rule 1, and therefore it dismissed the suit on that ground.
Oh, you said probably that is once it has been admitted, this.
Your Lordship, Your Lordship.
You are referring to some judgment probably?
Your Lordship, that judgment I have also given to Your Lordship. I have another copy. You
had cited it.
This is 2012 SCC Online, Odisha 411, Your Lordship.
Read.
Para 21, Your Lordship. It is therefore, Your Lordship.
Yes.
Para 21.
I highlighted it.
Your Lordship. Your Lordship.
That's all?
Another point, Your Lordship, on which First Appellate Court has dismissed the suit, Your Lordship. If Your Lordship may come to page 21, Your Lordship. Page 21, para number 36, Your Lordship.
Yes. Limitation.
Limitation, Your Lordship. With regard to the limitation, I find that the objection case number 616 of 86 filed at the instance of plaintiff was disposed of on 2/8/86. The suit has been filed.
What is this objection case?
During the settlement, this plaintiff has filed the objection case to record the land in her name, Lordship. So that was dismissed on 2/8/86. The suit has been filed on 2/1/1999 after expiry of 12 years for the of the period of limitation, Lordship. Now this here, Your Lordship, after the dismissal of this objection case 2/8/86, appeal was preferred, and that appeal was disposed of on 87, Your Lordship. Exact date, Your Lordship.
That has not been taken into consideration.
Not been taken into consideration. 12/3/1987. Now the suit has been filed on
2/1/99.
2/1/99. So it is within 12 years. Now second aspect, Your Lordship.
2/1/99
February, January.
Your Lordship. Because 12 year will be completed on March.
Appeal reject hala.
Appeal rejected on, Your Lordship. 12/3/1987, Your Lordship.
1980. Oh, all right. So it was filed before
January
March 1999. All right.
Thereafter, Your Lordship.
Why was that fact not brought to the notice?
So, if I summarize my submission, Your Lordship, on the point of Order 41, Rule 11, Lordship, I have already given that judgment that.
Order 41, Rule 1.
Rule 1. I'm sorry, Lordship. I have given that judgment that once appeal has been admitted, then it cannot be dismissed at the subsequent stage, Your Lordship. The secondly, Your Lordship, in respect of this adverse possession, that since there was no plea and the property is ancestral property, admitted fact, so adverse possession could not be held to be in favor of defendant, Your Lordship. Third, in respect of, Your Lordship, that partition, Your Lordship, I am relying on that sale deed, where they have clearly admitted in the recital that there was a partition between Gora and Dullah. And since recitals are very clear, so therefore no further evidence can be given. And they have admitted that sale deed. They have never disputed that sale deed. So therefore, Your Lordship, on the basis of that, the plaintiff is entitled to the decree, Your Lordship.
All right.
One more submission, if Your Lordship, I may.
Yes.
Since this belongs to Santal community, Your Lordship, they may not have right of co-parcenary right, but they will be governed by old Hindu law, Your Lordship. So even if Your Lordship held that there is no partition, Your Lordship, then by way of notional partition, she is entitled to share that will come to her father, Your Lordship. That aspect has not been dealt by both the court below, Your Lordship. So even if this honorable court finds that there was no partition, then also she is liable, she is entitled to get the her share through notional partition, which will come to her father. So that is my humble submission.
Hearing concluded, judgment reserved. Counsel for the appellant may file a brief note of submissions and memo of citations, if any, within a week.
I'm grateful.
You have argued well. Why are you asking for time? Every time when the matter is called out, you are asking for time.
I'm sorry.
You have argued very well. What is your name?
Ramesh Agarwal, Your Lordship.
Ramesh Agarwal.
But in fact, CPC has been amended to that effect.
The 41, yes,
41 rule.
Nobody word. Point out you don't have to give a detail. You just have to bullet points. This is the point, this is your submission, and this is the decision.
I'll do that, Your Lordship.
Now there is no decree is mentioned.
Yes, yes. Aguru decree, it has to be accompanied. Yes.
Okay, sir.
Item number 24.
I am appealing for the response number 2, my lord.
Item number 24. Order 41, Rule 11. Kalikon ki appeal karo. Pass over kare till Friday jaye jibo. Friday jodi ki appeal karibe ni tahale. Dekhiye.
Last occasion also same. 5 तारीख रे केही नथिले.
ना last week रे भी थिला.
नहीं 5
हाँ अच्छे देखिए. So since it's in the weekly list, we'll take it up till the last day and then Is item 25?
Item number 25.
For the caveator respondent, a copy of the appeal may be served on.
Yes. Let a copy of the appeal memo be served upon the caveator. Or list this matter in the week commencing
5th August.
5th August.
Item number 26.
26. I am for the respondent and the caveator, my lord. Copy has not been served to me.
Serve a copy. Let a copy of the appeal memo be served upon the caveator. List this matter in the week commencing 5th August.
My lord, obliged.
Item 27.
May I please, your lordship?
27, my lord, I am appearing for the respondent, my lord. My lord, I was unable to collect some documents, my lord.
Have you received the notice?
My lord.
Yes.
You have received you are appearing after notice.
My lord.
Notice was
No, my lord, I appeared after the limitation notice.
Limitation.
my lord.
To serve.
We have already served the appeal memo.
Anyway, we'll take it up for admission. But admission ଟା ଆପଣଙ୍କର କଣ କହିବାର ଅଛି?
କିଛି କହିବାର ନାହିଁ ମାନେ ଯେହେତୁ appear
କରିଛନ୍ତି ରହିବ କଣ? We'll take it up for admission. Let us admit it. If at all it can be admitted. If it deserves to be admitted. କଣ ହେଇଛି କୋର୍ଟ?
My lord, this is a suit for specific performance of contract.
First କୁହନ୍ତୁ reversing na
My lord, it's a confirming judgment.
Confirming judgment.
But both
Yes.
the courts have given separate finding. I was the plaintiff in the case. And I was the prospective buyer.
Suit for specific performance of contract in respect to the suit land hiring receipt of balance considerable. Yes.
Now in the
You are the plaintiff.
I was the plaintiff, my lord.
Yes.
In the said case, my lord, there was an agreement to sell with a stipulation that after getting the approval from the consolidation authority, are going to sell the property. And the defendant was the prospective seller.
34, section 34 application.
My lord.
How can how section 36A has come into picture?
My lord.
I have recently delivered a judgment. It validates all such. Anyway, but that is besides the point. Recently delivered a judgment.
The first appellate court stated
what happened. So you had what was the contract?
That you are going to sell the property after getting the sanction from the consolidation authority.
Yes. Then
the trial court, my lord, dismissed my suit on the ground that the said land was recorded along with other 4 co-tenants. So the agreement to sell is void ab initio. Page 18 is the operative portion.
Page 18, yes. Running page 18 or internal page?
Running page 18.
Yes.
The suit is a chocolate in view of aforementioned admission. The oral evidence adduced in this regard needs no consideration. Now let me find out if Exhibit 3, a registered agreement to sell, is enforceable, and if so, to what extent. As you know, an agreement enforceable by law is contract. All that is essential is that there should be a valid offer, unqualified acceptance, and agreement of the parties to abide by the terms and conditions to perform their respective part of contract. Then, my lord, to get a discretionary relief after 3 months, to get a discretionary relief, the plaintiff is expected to approach the court with clean hands, and her conduct therefore plays an important role. A perusal of recitals of Exhibit 3, it is seen that the defendant entered into an agreement to sell out of his share as reflected in ROR, while Exhibit 1, undisputedly Exhibit 1 is mutation ROR, stand recorded in the name of 4 tenants, including the defendant in the suit. Law is set at rest that mutation of a property in the revenue record does not create or extinguish title, nor has it any presumptive value of title. It only enables the person in whose favor the mutation is entered to pay the land revenue. Undisputedly, there is mention of share noting against each tenant. In other words, I am to hold that defendant had no exclusive title over the suit land to convey in favor of plaintiff, which otherwise renders Exhibit 3 as a void document. Then, my lord, we prefer an appeal. This was the only finding of the
ROR. Here it says that there was a noting regarding the shares, individual shares of the tenants, co-tenants. What was that share? केते extent?
In the present case, my lord, it is around 10 decimal of land.
Arvata
Arvata.
Note remarks column रे लिखा है तो देखो.
Altogether, it is total 475 decimal. Remarks from the
Pass it on. Correct. So, was it your case that the document was valid only to the extent of your share? Admittedly, you had a share.
But
you were not exclusive right.
I was the prospective buyer.
No, I mean the defendant who wanted to sell you. That is why it has been treated to be invalid document.
He has the share to sell the property.
So the total property कितना है सेतरे?
475 decimal.
475. What was the agreement for?
10 decimal of land.
So what is your case?
My case is that I had a readiness and willingness to enter into contract.
No, as regards this finding that it is invalid because he did not have any exclusive right. That is true. He did not have exclusive right.
Lordship may come to the finding of the first appellate court. Page 45 on this.
Page 45.
The first appellate court state that the
just a moment. Yes.
The mutation ROR clearly shows that the defendant along with others are the owners of the suit plot with some other lands, but exhibit 2 shows that suit land has been purchased by defendant from one Srinivas Bisoy. So even if the suit plot is jointly recorded in the name of plaintiff and others, they have inadvertently referred to as plaintiff. It will be defendant. Section 44 of TP Act recognizes the right of a co-owner of an immovable property to transfer his share in the said property or any interest therein who is legally competent to make such transfer, and the transfer is acquisition to such share or interest, and the transferor's right to joint possession or other common or part enjoyment of the property, and also to enforce a partition of the same, but subject to conditions and liabilities at the date of transfer. The only exception to provision of law is that where the transferee of a share of a dwelling house belongs to an undivided family, is not a member of the family, nothing in this section shall be deemed to entitle him to a joint possession or other common or part enjoyment of the house. Then Lordship, finally they have concluded that thus there is no legal bar for a co-sharer in a joint property to sell out of the said property if it is not in excess of his share.
That is what I was suggesting.
My lord. Then Lordship, the first appellate court said that since 34 and 35 is a bar, so agreement to sell is not enforceable.
So that part has been taken care of by the recent amendment of section 36A.
December amendment.
So he says that the agreement to sell the suit land having an area of acre 0.08.8 out of it is not in excess of the defendant's share. All right. All right. Heard Sri S.S. Mahapatra, learned counsel for the appellant, produce the impugned judgments. Considering the submissions and the grounds raised, the appeal is admitted on the following substantial questions of law. You have not taken these grounds.
My lord,
One, whether the first appellate court was correct in dismissing the appeal, despite holding that the land proposed to be sold to the plaintiff was well within his share of the ancestral property. Next, what would be the effect of the amendment? What would be the effect of the provision under section 36-A of the OCH and PFL Act to the proposed to the contract for sale? No notice need be issued as the respondents have already entered appearance. The respondent has already entered appearance. Let a copy of the appeal memo be served upon him. LCR may not be necessary. You have the certified copies of the ROR and everything, the contract and everything.
Xerox. The Xerox.
Certified copy nahi?
No.
All right. Call for the LCR. This is a short point. It will be disposed of very quickly. This is matter on
12th August.
How to
27th August.
this matter in the week commencing 27th August for hearing.
Okay. 28.
May pre-judgments. It's a reversing judgment.
Admission कितना अच्छी? Reversing judgment.
Reversing judgment. The plaintiff is the appellant here, my lord. Plaintiff has filed a suit for partition. The specific case of the plaintiff is that the land in question is the ancestral property of ancestral property, and originally it was belongs to one Baliyar Singh Naik. He had three sons. In the 1967, the property has been divided amongst the three sons of the Baliyar Singh by title suit number 12 of 1962. And the present property in question is allotted in the name of the Biranchi Narayan, the youngest son of Baliyar Singh. The Biranchi Narayan had two daughters only, the present appellant and the respondent number 1. After death of the Biranchi Narayan, the present appellant filed the suit for partition against the sister. Sister appeared and filed a WS that during the lifetime, the Biranchi Narayan has willed out the property in her favor and also sold certain portion of the property in favor of the defendant number 3, who is the husband of the defendant number 1. And also defendant number 1 alienated certain property in favor of the defendant number 2. Accordingly, the plaintiff has amended the plaint and the defendant number 2 and 3 added as a party. Thereafter, my lord, the issue were framed. That is at internal page 5 of the
issue number 6 is important.
Yes, my lord.
But issue number 6 is
while deciding the issue number 6 and a trial court. Balangir.
Probate is not required.
Probate is not required.
Yes.
While deciding the issue, and court below found that the will as well as the sale deed were executed by the Biranchi Narayan when he was ill and was staying with the defendant number 1 and 3. So the court below created a doubt of the genuineness of the will and the sale deed. Accordingly, the suit was allowed and partition was allowed. Then the respondent number 1 filed the first appeal. In the first appeal, it has been negated.
Let us see. What is the finding?
First appellate court. Internal page 10, my lord.
Yes.
The second way, however, it is admitted that the father of the plaintiff died prior to the year 2004 and much before the commencement of the Hindu Succession Amendment Act 2005, and alleged willnama and the RSD are executed much prior to his death. It is not disputed that he had acquired right title, interest and possession over the suit land after the alleged family partition in his family.
Plaintiff and defendant number are the admittedly the only successor of late Biranchi Narayan. And counsel for the appellant submitted that in view of the section 6 of the Hindu Succession Act as amended in the year 2005, if any partition or alienation has been effected before 28 December 2000, right of the daughter by birth. That is the law, but what is the finding regarding that will? He said that it is a genuine will because it is a registered will. And he has. And will is not required to be registered compulsorily. No, it is not compulsory, but it is a registered will. And the will was proved according to the law, according to section 68. Yes, well, the tested, the witness has been examined. But the circumstances which the suspicious circumstances, that has not been answered. That has not been answered. That has not been answered. All right. This being a reversing judgment, so naturally. But Sri K. Guru, Learned Counsel for the appellant, peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Two again? And the two. We'll add if necessary. Yes, issue notice to the respondents by registered post, fixing returnable within 4 weeks, requisites be filed within 3 working days. Call for the LCR. List this matter in the week commencing September. 17th September. You think how? Good. Did not
29 it last occasion your lordships are directed to take an instruction whether there would be a mediation. I am in my fag end of life 68. I am 68. My wife is
68 fag end of life.
Lordship, I am suffering from
what you are submitting is
I am suffering from urinal disorder. That is my problem, your lordship. And we are living in same village.
What do you say? If you are agreeable, I can send it to mediation. If you agree, there's no.
And more jo certificate she is my wife, my official certificate.
What do you say, sir?
So let's hope for
another person, so that the dispute arises, and for that genuine grounds, for their sustenance, he filed the case for enhancement of the 3,000 to only 7,000 claim.
No, the last occasion also you have said the same thing. But what I would say is that if you can have
only the ground limitation, only the ground.
No, if you agree, if both of you can have an agreement, a mutually acceptable agreement, well and good. If not, I am willing to hear this matter.
There is no any.
All right, then we'll hear it. We'll take it up. This has come for admission.
Yes, sir.
I'll tell admission. आपनका किसी role नहीं ताका कथा सुनिए आमे. We'll take it up day after tomorrow. 29 रखियो.
29 out case.
29 item 29. नहीं रखते 29 तो. This is item 29. It will be called out day after tomorrow. That is what I'm saying.
Can I prove lots of items 47? One Passover for till Friday.
Passed over.
Friday.
Item is already passed over.
Item 40 रे पूर्व डेट ऑर्डर अनुसार ऑर्डर ହେଇଛି पेन ड्राइव रे ଆମେ ଆଣିବୁ ଏସିଆ ନୋଟିଂ ମଧ୍ୟ ସେଇ ଅଛି
ହଁ नो ना पेन ड्राइव आनो तो
पेन ଆଣିଛୁ ଯେ
कोन
କଲେକ୍ସନ କଲେ ଟିକେ 1 वीक ପରେ ଆସ पेन ड्राइव रे एसी ଏବଂ ଆପେଲାଣ୍ଟ ଆଡଭୋକେଟ ऑर्डर
आइटम 40 तो
आगे
और 2005 मसीहा मैटर दिस मैटर इन द वीक कमेंसिंग 29 जुलाई
सर आसु के पेन ड्राइव कलेक्शन कर
29 जुलाई यस
नेक्स्ट टू गेल अछि
the 22 we commence 22
हां हेलो 22 28 29 sorry this matter next week what matter as well
interim order to continue
interim order to continue
admission
yes Satish
47 on Friday will 47 on
Friday will mark